Welcome to day 2, session 1. Yes, please, come in. Day 2, session 1. Moment of truth. Yep, for many of us, I think. My name is Dave Behrens. I work for Crossroads Distribution, and I'm on the board of the RFA. Have been for a long time, and have also been attached, literally, to the old Road Freight Employers Association, which is now the Labour Relations Committee of the RFA, for many decades. And we're obviously coming up to a busy time, which our first speaker will no doubt touch on in terms of the wage negotiations. Please put those cell phones off or onto silent. We were quite good yesterday. I think there was only one from a furniture removal MD, who I'm not sure if he's here. Anyway. And then, as usual, what we will do is, before we get to the first speaker, I think let's just take another look at the RFA DVD. And, yeah, let's hope we all wake up after that. Right. It gives me pleasure to introduce our first speaker, who is Morsina Chenia. She's from Cliffy Decker Hofmeyr. And she's going to look at some of the changes on the labour terrain, and also the movement in the expectations of organised labour. She's also dealing with a number of cases with a number of us through the association or its members, dealing with issues like the dual driver application and the payment thereof, and also the whole tarping issue with the driver's duties. So we look forward to getting some insight into that. So, Morsina, over to you.
So I've just learned how to turn this on. Good morning, everyone. 78%, I think, is an excellent turnout after last night. So for those of us who are here in body, mind, and spirit, thank you very much and welcome. For those of us who are here in body only, I wish you well on your mind's journey. So in keeping with the theme of the conference, Moments of Truth, we've selected 3 moments of truth to chat about. So I'm not used to doing this. I'll normally have a CA who changes my slides for me, but I'm going to try and do both together, try and be less like a man and do 2 things at the same time. So I apologize. I know that males are in the majority, but so apologies. So the first topic I would like to chat about is temporary employment services. We know that this has been a very hotly contested debate in the last couple of years, with the unions demanding a total ban on labour broking, business fighting for its preservation, and some sectors very concerned that a total eradication would increase unemployment. So ultimately, this culminated in the... So let's just start the panic stations. Ultimately, this culminated in the amendments to the Labour Relations Act on 1 January 2015. We'll talk about that in a moment. Let's just quickly talk about where it all started with labour brokers. We know that previously the legislation stated that labour broker employers remain the employers of the workers. There was limited joint and several liability in respect of clients. Clients were jointly and severally liable in relation to issues such as collective transgressions relating to collective bargaining agreements, Basic Conditions of Employment Act, sectoral determinations, and some awards. With the changes, we look at, perhaps let me go back to the previous slide. Why did the changes come about? It's to protect vulnerable employees. Who are vulnerable employees? They are those who work for an employer in excess of 3 months and whose earnings threshold, whose earnings are below the threshold. We know that the threshold currently is just over 205,000 Rand. So how did the legislation seek to protect employees? Firstly, by the deeming provision. We know, because it's been spoken about quite substantially, that clients of labor broker employers are now deemed, well, let me go back and rephrase that. Workers of labor brokers who work for longer than 3 months are deemed to be employees of the clients. That's the one protection. Second protection, they are to be treated on the whole, not less favorably than the employees of the client. Thirdly, they become indefinite employees of the client after the 3-month period. And then there's an extension of joint and several liabilities. So the liability of the client of the labor broker extends to all purposes, including those in the Labor Relations Act. The one further amendment was in terms of Section 198(4)(a), where, well, that's the additional protection for labor broker employees. So if there's a transgression and they seek to raise disputes, they can do so either against the labor broker or against the client or against both. And if there's an award against either one of them, that award can be enforceable against either the labor broker or the client. So what has happened since the amendments? There have been many, many disputes that have arisen. The one, which is currently before the Constitutional Court at the moment, is NUMSA and Assign. Started off at the CCMA. The CCMA found that the sole employer test is what was intended by the legislator, meaning after 3 months, the client becomes the sole employer and the labor broker moves out of the equation. The employer party is obviously very unhappy with this situation, took the matter to the labor court. The labor court found that, and this was Acting Judge Martin Brassey, found that a dual employment relationship came about as a result of the amendments. Number one, the labor broker still remained the employer of the employees. The employer became the second, or rather the client of the employer became the second employer for purposes of the Labor Relations Act. So the labor broker was very much the employer, although there was some liability in respect of the client. Unions very unhappy with this, and we know that NUMSA's argument is that after 3 months, there is in fact a ban of labor brokers, a complete ban of labor brokers after 3 months. And that was the argument, I think, that was raised at the Constitutional Court as well. Comes Labor Appeal Court. They go back to how the CCMA found, and that is sole employer. Now, I'm not going to spend too much time on it, and I don't know who may be interested. We can chat about it a little later, but I can just get to my notes in a moment. Just dealing with what the Labor Appeal Court says and how it came to its reasoning as to why it is, in fact, a sole employer relationship. So the first is I don't know how this works, but fully integrated into the enterprise. In other words, the labor broker employee becomes fully integrated into the client's enterprises. So that's the one reasoning. Second reasoning is the TES, or rather the plain language of, and that's the second, that's over there, the plain language of the legislation supports the sole employer interpretation. However, our opinion and employers' opinion is, does it in fact support the sole employer interpretation? Is it not built into the legislation that you have the protections built in respect of clients, and then you have the protections in respect of labor broker employers? So I'm not sure if that argument is, well, it's an argument to be made. We'll see how the Constitutional Court decides on that. The next issue is that the Labor Appeal Court looked at is whether there is in fact a transfer of a contract of employment from the labor broker to the client. What the Labor Appeal Court found was there isn't a transfer of a contract of employment, but actually the creation of a statutory relationship between the client and the placed worker. And that statutory relationship exists completely separate to the relationship between the labor broker and its employee. So what in fact this means is if the labor broker dismisses the employee, that statutory relationship after 3 months still exists between the client and the labor broker. And after 3 months, the labor broker then falls outside of that relationship. So, like I say, I'm not going to spend too much time on what the Labor Appeal Court said, but at the end of the day, this is what it found. The placed worker becomes employed by the client for an indefinite period on the same terms and conditions to employees of the client performing the same or similar work. In other words, after 3 months, labor broker is gone, client becomes the employer of the labor broker employee. Where does that leave us? What is our current position? There seems to be some different views on where we are at the moment. We know that Section 18(1) of the Superior Court Act says that any decision that's been taken on appeal, that decision is suspended until such time that the higher court makes a decision on that. So in terms of that act, and we know the Labor Appeal Court is a superior court, in terms of that act, the Labor Appeal Court decision has been suspended. Does that mean that the Labor Court decision dealing with dual employment has been resuscitated? Some feel yes, some feel no. Those that feel yes, it's been resuscitated, we're now sitting with a dual employment relationship. Those that say no, say that there's no position in law. And some senior counsel have had those discussions with us. So we wait anxiously and patiently for the Constitutional Court to make a final decision on where we are with regard to labor brokers after 3 months. We couldn't find out when it's anticipated to hand down judgment. What we do know that it is more than likely that the findings are going to depend on who writes the judgment at the end of the day. Just a little bit of sharing of information on this particular study that was conducted, the source is CAPES. Post the LRA amendments, there seems to be an increase in the number of terminations. 45.3% terminations after the amendments, 5.5% retrenchments, 6.52% taken on contract, 20.71% taken permanently, in other words, by clients, and 22.05% are unaffected. What does this tell us? That all it's going to do is increase unemployment. What I must just quickly add is the researchers who came up with these figures couldn't, with conviction, say that or infer from this that it's directly related to the amendments. But they reasonably could infer that it relates to perception of employers in relation to those amendments. Consequences, very briefly, some of them are absurd. So where there's a strike at an employer's premises, those who are below the threshold can strike, those who are above the threshold can't strike. Retrenchments, if the client sends out a notice of retrenchment, TES employees below threshold can need to get notice. Who serves the notice on them? Must it be the client? Must it be the labor broker? Not sure at this stage. However, TES employees above the threshold, the TES must still give notice of termination, and TES is temporary employment services, as we all know. Alternative models to look at, because temporary employment services are becoming a concern for us. And Hugo was intimately involved in one of the matters, the Checkers, the ShopRite matter, where there was a different form of a relationship in the sense that there was a managed service provider. So many employers look to concentrate on their core services and they seek to outsource the non-core services. In this respect, it related to a warehouse function, where the skills in relation to warehouse functioning, Adfusion had that skill. So they appointed the managed service provider, Adfusion, to provide that skill. Taking ShopRite outside of that equation, the managed service provider deals with TESs, deals with the employees, it becomes the client, and as long as there's a genuine distance in the relationship, that was found to be it was found to be a genuine, acceptable relationship in compliance with the Labor Relations Act and not in contravention of, in terms of Section 200B of the Labor Relations Act. Another alternative could be to rely on labor brokers who provide a service rather than the productive capacity of employees through labor brokers. So those are just possible alternatives. Moving on to moment of truth number 2. So in the past, many employees in the industry have been facing challenges by unions and employees regarding drivers' duties and dual driver arrangements and payments. Individual employers have had to deal with very complicated disputes, either through interpretation disputes or dismissal disputes where drivers refuse to comply with certain instructions relating, for instance, loading, offloading, tarping duties, etc. So what I must add here, I have to go back a step. There's something I completely forgot to mention about TESs. In terms of the main agreement, temporary employment services employees become ordinary employees after 2 months and not 3 months in relation to the Labor Relations Act. But it's not as specific as the Labor Relations Act. It says they become ordinary employees, which means they receive the protection of the main agreement. Below 2 months, they are only protected in relation to certain instances in the main agreement, and that is what would affect you in the industry. Coming back to this issue of interpretation disputes, RFA has successfully drawn party unions to have these disputes determined at a national level. We've been involved in this, and the first of the disputes in relation to dual drivers is about to be heard on the 20th of June. It has been postponed. We are hoping that we'll get some clarity on the 20th of June this year. So what exactly is the dispute? Dual driver dispute is set out in Clause 67A of the main agreement. As we all know, dual drivers means 2 drivers simultaneously engaged, sharing duties on one vehicle on the same journey, and the trip is divided between the 2 drivers, the one driving, the other at the back in the berth during the rest period and paid a subsistence allowance. Each driver is paid their ordinary hours of work plus overtime up to a maximum of 15 hours for those driving. And the subsistence allowance is a dual driver subsistence allowance, which is slightly higher. As I understand, it's 218 Rand at the moment to the dual driver that's during the rest period. For those drivers who don't qualify for the subsistence allowance, they get paid the difference between the dual driver subsistence allowance and the ordinary subsistence allowance. So what's the difficulty? The unions claim that in instances where drivers drive away from home, driving in the vehicle, they are in readiness to work, and that's going to be the catchphrase during our arbitration and today as well. I'll come back to that in a moment. So what unions believe that they are in readiness to work, even though they're sitting at the back in the berth, they are effectively working a 24-hour shift and should be remunerated accordingly. That's where we get this. Initially, however, the demand from the unions were that each driver must be paid a full 15 hours salary, irrespective of whether they are driving or not. In other words, even if a driver is during his rest period getting paid a subsistence allowance, he must still be paid a 15-hour salary because he's away from home, he's in the vehicle, he's in readiness to work, meaning if something happens to the other driver, he's required to take over, and for that reason, he should also be remunerated. I'm not sure what that would do to the industry if that is in fact the position, but I'm sure you will be in a better position to tell us. What do employers say? Employers say the debate centers around the definition of hours of work. And this is what we say. The definition is pretty clear. Hours of work includes, number one, all periods of driving. Number two, any time spent by a driver, security officer, or any other employee on other work connected with a vehicle or its load. Other work may be if there's a puncture, if the load needs to be secured, anything in relation to the vehicle of the load is other work. That constitutes working hours. 3, all periods during which the employee is obliged to remain at his or her post in readiness to work, pause, when required to do so. What does that mean? And I understand that often vehicles arrive at a client's premises to load, offload, and there's a long queue, but they're required to stay in the queue until such time that they can, in fact, offload. They can't move from the vehicle because they have to move at any given time. They can't leave the vehicle. They have to be there ready when their turn in the queue comes. That means they are in readiness to work. They're not driving. They're in the vehicle, but they are in readiness to work because the employer requires them to be there to ensure that the offloading takes place. And that, I think, is what is intended by this. So those are the instances that includes hours of work. There are exclusions. What are the exclusions? Number 1, a meal interval. Number 2, the period during which the subsistence allowance is paid, and that subsistence allowance in terms of section or clause 36 of the main agreement. Number 3, they do no other work but remain in charge of the vehicle or its load or guarding. Those are the exclusions. So let's get to the off-duty driver who wants to be paid 15 hours in addition to his subsistence allowance. Let's look at his position. Number 1, he or she is not driving. Number 2, they're doing no other work in connection with the vehicle or the load but sitting at the back. Number 3, they're not in readiness to work, and this is important. Why are they not in readiness to work? Because the employer doesn't require them to work. And we know in terms of the main agreement, it's the employer that decides commencement times and shift times of employers. So the employee can't say, I'm in readiness to work because maybe something happens to the driver or I'm required to help change a tire or something like that. That means I'm in readiness to work. So that's not the case. They paid a subsistence allowance. They have to be in a compulsory rest period of 9 hours. In fact, there's an obligation for the rest period. No employer may allow an employee to work during the rest period, so they can't, in fact, work during the 9 hours. And therefore, we say it's not working hours, and there's no 24-hour shift and no requirement to pay any additional remuneration other than the subsistence allowance for the second driver who's not driving. I'm going to touch on a few examples that we came across. The first being, and I don't know, Esther, this is you. So we have a situation where vehicles would leave, for instance, Cape Town, travel to Johannesburg for offloading. They would leave on a Thursday or a Friday. They arrive on a Saturday at the Johannesburg depot. They obviously can't offload because of the weekend. They can only offload on a Monday. There's obviously a waiting period the Saturday afternoon, the Sunday, and the Monday. However, the driver is not required to remain at the depot or with the vehicle, although most of the times I understand they stay over at the depots. What the unions believe and drivers believe is that waiting period during which they are paid a subsistence allowance, they paid that subsistence allowance because of the time, because of their duties as a driver, meaning driving, offloading, etc., and the subsistence allowance is linked to that duty as a driver. So for that reason, they should be paid for the full ordinary hours on a Saturday, well, the Saturday hours as well as a Sunday, until such time that they offload. So what they're essentially saying is that constitute hours of work and they should be remunerated for that. This was an arbitration, and the employer submitted a similar argument to what I've been talking about earlier, meaning that you're not required to work, you're during your rest period, you're being paid a subsistence allowance, you're doing nothing other than either being in charge of the vehicle or the load. For that reason, it doesn't constitute hours of work and we don't need to pay you. The award was in the favor of the employer, and the commissioner found that it did not constitute hours of work. There was no requirement to pay. It's a second example with similar set of facts, but in the strike context. The union demanded that those employees who deliver on a Monday, travel long distances, deliver on a Monday, they should actually leave on a Saturday afternoon or on a Sunday to ensure that they are in time to deliver on the Monday. What that essentially means is they are required to be paid 1.5 times on the Saturday and double time on the Sunday, which increases their wage packets, increases the cost to the employer, but they believe they're entitled to that because they're away from home. They have a little bit of additional time with their family, and, well, that was the demand. We then proceeded to interdict. That was the demand. They were about to strike on it. We approached the Labour Court for an interdict, arguing that the demand by the union and the employees is a cost to the employer. A cost to the employer constitutes a substantive issue in terms of the definitions in the main agreement, and we know that substantive issues can only be negotiated centrally at council level. And for that reason, the employees can't strike on that issue. Very strangely, Judge Witcher heard this matter, and she found that the demand did not relate to cost. It is, in fact, a work practice that was peculiar to that employer, and that could easily be negotiated at plant level. Because the demand itself did not amount to money, it's only the consequence of the demand that amount to money. We were obviously unhappy about that. We've taken the matter on appeal and we wait for judgment on that matter. We're still of the opinion that the demand relates to money because it increases the wage packets of employees. Some disputes arose in relation to drivers' duties. Unions, employees used the definition of driving and drive to seek to demand that, or they have the opinion that their job description is limited to only driving and no other additional duties, for instance, loading, offloading, tarping, guarding, etc., etc. This matter came to court for some consideration, but also in the context of a strike, where Judge Lagrange had to deal with whether employees were required or drivers were required to load, offload. This was in circumstances where those drivers, in fact, had those obligations in their contracts of employment, firstly. Secondly, it was also in the standard operating procedures of the client at which they loaded and offloaded. This was in a matter of Unitrans. I think Hugo initially started off with it. I ended with it. But Judge Lagrange found that the demand that drivers no longer perform those duties, but in addition, general workers must be appointed to perform those duties, amounted to a cost to the employer, which amounted to a substantive issue, which demanded negotiations on substantive issues at plant level, which was obviously prohibited in terms of the main agreement, and the strike was successfully interdicted. So those are just some of the issues that come about, and we do have a second arbitration. We don't have a date yet that's going to be dealing with exactly what drivers' duties are, hours of work are, etc. We don't have a set down date, as I've indicated just yet. Moment of truth number 3. We know that wage negotiations are large and looming in our industry. I understand that demands are about to be received from the unions next Wednesday, or this Wednesday, and negotiations start, I think, starting on Monday. Is that right, Shamini and Mugresha? So traditionally, we know that unions have always submitted a shopping list of demands for negotiation, which in the road freight industry included issues such as the extended bargaining unit and other ancillary issues not directly linked to wages and conditions of employment. We've seen in the recent bus strike that the issue of dual drivers has also been included as a bargaining subject, which would certainly have been in the case in the road freight industry if it wasn't taken out of the negotiation sphere and into the adjudication sphere. As lawyers, we always like it to be taken into the adjudication sphere, mostly because I think there's just better control over the outcome than leaving it simply to negotiation between the parties. So just another breakthrough, I think, achieved by the RFA in relation, and which is certainly going to assist in wage negotiations, is clarification of the issue of the extended bargaining unit. I understand that agreement has been reached at council level to clarify exactly what is an extended bargaining unit employee, and very importantly, an extended bargaining unit employee is linked to the threshold, which means any employee who earns above the threshold cannot now be an EBU employee. The purpose of the amendment to the Constitution was to provide clarity and prevent further ambiguity with regard to EBUs, which we know has caused many, many disputes arising. We're currently dealing with one relating to a commissioner incorrectly identifying an employee as an EBU employee in terms of confusion between Schedule 5 and Schedule 7 of the main agreement. So we understand that negotiations are more than likely going to center around the rands and cents rather than other ancillary issues this year. Let us just look at some general observations and interesting statistics around wage negotiations in South Africa. This graph tells us what the current situation in South Africa is. Salary increases are inexorably linked to inflation. We've seen that it goes up and down depending on where inflation is. The next graph is, I think, of particular, it was an eye-opener for me, certainly, and I would imagine for the rest of us at the conference as well. If you look at salary increases over an average of 15 years and taking inflation into account, real salary increases did not amount to anything more than 1.8%. So we think 9%, 10%, 7%, huge salary increases. What does it actually mean for employees? 1.8%, 2016, less than that, 2017, a bit of an improvement. We don't know what 2018 holds for us. Where are we now with our economy? We know economic growth is already forecast to be very low, with no respite imminent. This puts pressure on employers. Employers need to consolidate, cut costs. What normally happens is job losses, mechanize, introduce technology, do whatever it takes to cut labor costs, to weather the hard times. This has the potential to result in below inflation annual salary increases and job losses due to affordability. On the other hand, we know that unions are facing a crisis of representativity. Union membership is declining. Only a quarter of the workforce apparently is unionized. That's in terms of the Cape study. We know that there's a proliferation of trade unions currently, and with the establishment of SAFTU, desperately looking to increase membership and taking on any challenges to achieve this end, including what we've seen recently, the protest action in response to the proposed amendments and to the national minimum wage. We've seen a springing up of workers' organizations. I think almost every one of us has come across casual workers' advice office in some way or another. And they believe that union membership is union representativity is in fact only 24% throughout the workforce. They also believe that there's been a substantial decline in federation representativity at NEDLAC level. So we're going to be dealing with those types of demands from workers' organizations as well. At the same time, we sit with the precarious situation in South Africa that income inequality in South Africa is amongst the worst in the world. Very, very scary statistics. South Africa, 63, Namibia, 61, right at the bottom, Cameroon. Something for us to consider, and we know in South Africa, this is unfortunately race-based, which becomes a difficult situation. This, we believe, is utopia, but it's something that both employers and unions are going to have to look at seriously in order to achieve less economic distress so that we don't have a further downgrade and do whatever it takes to reach agreement. I think employers are going to have to do a little bit more for two reasons. One, to get stability and labor peace for an extended period. Number two, to ensure that we preserve some sanctity in our economy. Let us look at some of the market trends and some examples learned from the industry. In other industries, I beg your pardon. But just before we go there, I would like to just add another dimension. In the road freight industry, there is an additional challenge where minority unions, not party unions, are looking to challenge representativity at the bargaining council. We know that a number of unions are seeking to make inroads into the council with possibly dire consequences. So that's an additional factor that employers are going to have to look at to ensure and take all necessary steps to secure the sustainability of the council. As we all know, that plant-level negotiations can be extremely onerous and difficult. So no matter how we look at it, it's going to be a difficult year for wage negotiations. This is a very interesting way of dealing with protest action in Japan. Currently, bus drivers in Japan are on strike, continuing to drive their routes. In other words, no disturbance to commuters, while refusing to take fares from passengers. So keeping Japan on time, but costing the bus companies gas on top of lost revenue. Dear world, this is how a protest is done. Meanwhile, in South Africa. This is a picture taken from the Mooi River Plaza and the subsequent N3 protest actions where we saw disastrous burning of trucks, looting, etc., etc. I'll come back to, well, I guess that creates also another additional challenge for the road freight industry, in the sense that it's not only dealing with minority unions, workers' organizations, it's also now having to deal with community-based organizations that are attacking. Apparently, these were attacks on foreigners and foreign nationals. And what does that mean? That employers now have to take a relook at employing foreign nationals. We know that with cross-border drives, these foreign nationals play an important part, knowing exactly how things work in those different countries. So not sure if employers have to have a relook at that in the industry. Now coming to market trends. The public transport bus strike, we know, is most related to this industry, and it's the most recent strike that has just been resolved. We know that generally employers have always tended to push for a multi-year wage agreement, as this leads to certainty and labor peace for an extended period of time. With the public transport bus strike, the employers sought exactly that, a 3-year wage agreement. Initial demand was 7%, whilst the union's initial demand was 12%, and a 1-year wage agreement. They eventually settled on a 9% salary increase in the first year, 8% increase for the second year, effective 1 April 2020, 19. And then the additional issues like the dual driver dispute, which formed part of the dispute, other issues of compensation, insourcing of certain workers, etc., were removed from the negotiation and pushed to a task team under the auspices of the CCMA to deal with. So these are the figures I think that we would be looking at in our industry going forward. And the reason why we say this is that two of the unions negotiating at that bargaining council, Satawa and Tawusa, are party unions of the Road Freight Bargaining Council. Two other unions, NUMSA and Terasano, apparently have applied or are knocking at the door. So I would imagine that these unions are going to bring these types of demands to the table, and and I think these are the kind of increases we should be looking at. The public sector wage negotiations, I understand, have reached deadlock. The unions are at CPI plus 3% for junior government, CPI plus 2% for mid-level employees. The government is at CPI increases for junior and mid-level and CPI minus 1 for senior government employees. Government is looking for a 3-year agreement. Unions are looking for a 1-year agreement. Unions are very averse to multi-year agreements. They believe it takes away their right to bargain and negotiate at each year. But when they achieve massive gains for consequent years, they do eventually buy in on multi-year wage agreements. The MEIBC, strangely enough, settled at reasonably low percentages. This was in July of last year. First year 7%, second year 6.75%, third year 6.5%. So what are we going to do about all of this? For the first time, I think in a long time, legislators have looked to amending legislation to deal with the reality that we are faced. We know that with wage negotiations, there's always a possibility of a strike, and strikes in South Africa are often violent, with victimization and harassment of non-union employees. In fact, we've had many, many occasions where we run to courts to interdict violence during strikes, even protected strikes. The courts have come on board and brought unions to task, particularly, and made them responsible for the employees who perpetrate violence during strike action. It becomes difficult sometimes when you can't actually link the violence to members of the unions, particularly where in instances where the EFF has now come on board and joined many of labor strikes. It then becomes difficult for employers to deal with those situations. Other instances where picketing happens outside of the employer's premises, it's difficult to control those instances. Legislators, like I've said, have come on board to deal with some of these situations, and I'm going to deal very briefly with some of the proposed amendments. They're still in the phase of comments being considered, but let's deal with what is proposed. The first is new picketing rules. Currently, picketing rules are the lack of picketing rules, absence of picketing rules is not a bar to the commencement of strike action. However, under the proposed amendments, the commissioner, CCMA commissioner, will have to issue picketing rules before issuing a certificate of outcome of dispute to enable strike action to commence. In the industry, in this particular industry, we know that it doesn't go through that process. But what I do understand is if parties have deadlocked, there are 2 dispute meetings under the auspices of a commissioner of the bargaining council. And in those instances, I do believe that these amendments will become relevant, and those commissioners will also be required to issue picketing rules before a strike can happen. I do understand that there's no collective agreement in the bargaining council currently dealing with picketing, and it may be something to look at for the future. So picketing no picketing will be permitted unless these three situations exist. Number one, the parties have reached agreement on picketing. Number two, there's a collective agreement in the bargaining council dealing with picketing, and like I said, it's something that should be looked at. Number three, the commissioner issues or determines the picketing rules on behalf of the parties. There are various things the commissioner would take into account: the nature of the workplace, the nature of the industry, where the picketing is going to be taking place, etc. Before I go on to the next amendment to Section 32, there's a further amendment that has come about particularly to deal with situations where there's threat of violence or violent strikes, and there's a provision that an advisory arbitration panel can be established to issue awards limiting strike action, limiting violence during strikes, etc. The advisory arbitration panel can be established on its own accord via the CCMA on application by a party to the dispute, where the Minister of Labour instructs the director to do so, and when the Labour Court makes such an order. Interestingly enough, the amendments also propose that the Labour Court may make an order requiring the director to appoint a panel in circumstances where the strike may affect a third party or outside party. So even those parties can now approach the Labour Court to establish an advisory arbitration panel. Difficulty with this panel is there has to be an arbitration, so in circumstances of urgency that's not going to help. Secondly, there has to be an acceptance of the award before it can be valid and binding. So it's still a tool that's available. I'm not sure it's going to be a very effective tool. Very lastly, amendments to Section 32. We know that previously the minister was the one who determined representativity and extensions. The legislation has proposed, and I think the reason for this is to prevent any legal challenges to the extension. And we know there have been many legal challenges, some of them successful, some of them not. What happens now is the registrar will determine representativity, which will be submitted, representativity of unions and employers, which will be submitted to the minister. The minister will be obliged to extend. The minister still retains the residual power to extend when the failure to do so would or could undermine collective bargaining. This is in circumstances where employers and unions are not majority representative but sufficiently representative. Unions' response to these proposed amendments, they are of the opinion that it erodes a lot of the progress they've made over the years. They're very, very opposed to these amendments. Last slide, I promise, is the illustration of what happens when there are any amendments. We see that work stoppages increase, and we know that the new amendments will have that. I think this is a message for me to finish. It will increase strikes. Simple truth, now we can panic. So I'm not even sure we need to panic. We know that this is a very dynamic environment. Change is a constant. We have many, many forces influeing our industry. I understand that we work on very small margins. Those are all difficulties we deal with. But in the words of Lovemore and Biggie, thank you for that, Professor, we either manage the change effectively or it happens chaotically. Thank you very much.
Rosina, thanks so much. And I think it just shows, from the balance of the presentation, it just gives an indication of what the relationship between the RFA and CDH Cliff Decker is. In that Rosina is fully conversant with everything that we're doing, with what's going on in the industry. She knows a lot of our companies very well. And with the help of the professor, I think it's a wonderful team. And we do really appreciate that, so that we can get these sort of inputs from you. We're running a little bit late, but I think we've got time for a question or two, if anyone has a question. Yes? Is there someone with a mic? They'll come through to you now. Do you want to come stand up there?
Hi. I just wanted to find out about you spoke about the amendment to the Labour Act, and you touched on temporary employment, but you didn't mention anything about fixed-term contracts. What happens if you go into a 3-month fixed-term contract and keep renewing the 3-month contract? That's the first question. I have a second one. Maybe we could handle that one first.
So you can renew fixed-term contracts. You can have successive fixed-term contracts. However, they must be for a justifiable reason if it exceeds 3 months. So it must be, for instance, where there's for seasonal work, where there's additional workload, so for instance, an employee is absent from work and you have somebody replacing that employee, for instance, going on maternity leave, so you would replace an employee for 6 months. So fixed-term contracts exceeding 3 months are fine as long as there's a justifiable reason for it, meaning it must either be for a purpose, it must either be for a project, or it must be of a definite duration.
Okay, on that one, what about probationary period?
So probationary period, if it's under 3 months, you're safe. If it's over 3 months, it doesn't fit within the definitions of justifiability, I think. So in the past, we would appoint employees on a fixed-term probationary period and then decide we didn't like them and not appoint them. I'm not sure that's going to be defensible any longer if it's exceeding 3 months.
Okay, great. And then the other one is just a driver that's on the truck. Let's assume he's driving from Joburg to Cape Town. He's on a project. His rest time is up. Say for instance, 5 or 6 days, and we say to him, right, you get off the truck, and you're actually on rest. But it's in a safe place. It's at the depot. You can actually use that for safe sleeping. What is the situation as far as remuneration is concerned?
So the scenario is similar to the one I've chatted about, is where they've completed their hours of work within their rest period. All they're doing is being at the depot, waiting for the next load. They're not in their working hours, and they need not be remunerated. If that's the scenario I understand you to be painting.
Including your night out allowances or any remuneration at all?
So if you're in your rest period, you have to be paid your night out allowance, your subsistence allowance, if it's during the rest period and you're away from home. So it has to be away from home. But if you're not away from home and not in your rest period, you're still not working. You're not required to work by your employer. You're not in your hours of work. So that you don't need to be remunerated.
Okay, great. Thank you.
Thanks. Okay.
All right. Any more double-barreled or triple-barreled questions? Yeah, sure.
Thank you. Mosina, it's not a question for you, but it relates to Don's question from yesterday about RTO, Don. Remember, and what do we do with those drivers? And I thought about it a bit. If I may come back to that with your permission and the program director's permission. I think the concern is not necessarily whether you're going to terminate or not. I think the concern when you deal with that driver is our insurance, because we may have a driver who's lost his license through RTO or otherwise, and there's an accident, and now we're not covered in terms of insurance because of the conditions of the insurance company. And what do we do as trucking companies, how to manage that? My sense is one will have to consider amending our contracts of employment. It's about POPI, the right to protection, and to have the right as an employer to have some sort of access to those employees' points, so that we would know in advance if there's a risk of that employee losing his or her license. And my sense is that we will have to contract to say that whenever the employee gets points against him, him or her, that employee has to disclose it, but on top of us affording us the right to access that information. Mosina, that would be there would be a POPI implication to that, I would think.
It would certainly, and I know there are employers already building this into their contracts of employment, because it's a huge problem where points coming in, but also where there are transgressions on the road, etc. It has an impact, obviously, but I think it has POPI implications. But it's important to build those into your contracts of employment now.
And then just in terms of termination, my sense was one will probably have to look at the analogy of incarceration and say that if the employee loses his or her points, it may not necessarily lead to the automatic termination
Correct.
of employment,
Yeah.
but potentially suspension without pay for the period of time. And then you'll have
Indeed.
to put temporary employees in, and that would be a justification for that. On Count Dracula's, I think it's Count Dracula speaking
Yeah.
from last night, on his question.
Yeah.
May I make a last quick program director,
The
just
floor
a
is
comment?
yours, Professor.
Thanks. No, it's just this new case law developing where people don't go to the labour courts anymore, and they go to the high courts and seek unlimited compensation. And just the sensitivity of employers when we look at potential infringement of dignity and all of that. And we've seen cases now reporting, the latest one is in fact in your bundle or in your RFA truck talk, where the person said to the employee, vra daai swart man om sy voertuig te verwyder. And where the dire consequences, and the court said that's a dismissible offence. And we just need to sensitize our management teams when we deal with our managers and our employees. I mean, we've had cases where the employee or the manager said to the employee, hang on a tak, meaning hang on a branch, I come now. And that was referred to the Human Rights Commission because that employee said the employee is a monkey. Or where the person said, julle is nuuskierige agies. And that developed into a point where they said, you saying ons is nuuskierige apies. And that was also referred to the Human Rights Commission and to the Equality Court. So it's about being sensitive and advising our management teams to be more sensitive in dealing with our employees. Those were just some comments.
Okay. Thanks very much for that. I think let's just say a big thank you then to Machina. Thanks for giving up your time.
Absolutely.
Just a small token of our appreciation.
Thank you so much. Appreciate it.
All the best.
Thank you. Thank you.
Thank you. Thanks. Machina.
Thanks.
All right, let's try and just speed it up a little bit. We mentioned insurance and other issues, and Sasria is actually sponsoring this particular session, and they might have a few minutes at the end of the session just to talk about it. But that little, have a look at that little diagram illustration there. It does tell a story, especially about what's been happening in the last few months. Right, if you look into your Moment of Truth program, you'll see a wonderful CV of a young lady called Tabi Leoka. I'm not going to go through it. It's very, very impressive. And yeah, she is what we call a highly acclaimed economist, and is here to look at what you see up there, RET, R-E-T. Well, I can see it here. It's this radical economic transformation has been widely bandied about, but the term hasn't really been unpacked into practical terms for any implementation whatsoever. It's just something that's hanging out there for now. And according to President Ramaphosa, it's about implementing programs that deracialize ownership and control of our economy to benefit South Africans as a whole. And we're hoping that Tabi will share her insights into this and give us an idea of what that could possibly mean. So Tabi, over to you.
Still in the morning. Morning, everyone. So I've been given the task to talk to you about radical economic transformation and what it means for business. And I thought to myself, geez, you know, I really didn't like the word radical economic transformation, only because it's a word that was used a lot by the Zuma administration when it tried to deviate, or at least attention, away from their shenanigans, their corruption, and then suddenly there's this word that was used and passed around by the ANC. But actually looking at South Africa as an economist over the years and looking at the future of South Africa's economy, you realize that there's a lot that needs to change radically. I think the word radical is a bit too hard. I remember saying to Enoch Godangwana from the ANC that why not use the word, accelerated? But then remember we had a SKISA, which was the accelerated program that didn't really accelerate. And so then he thought, no, radical economic transformation is what the ANC is going with. So what is radical economic transformation? I said it's inclusive growth, because growth needs to be inclusive for us to see the growth that we want to have in this country. I'll go through, you'll see other graphs on the South African economy and why we cannot take off economically. It's also accelerated growth. So not only growth has to be inclusive, but it has to accelerate and has to be sustained. Reindustrialization of the economy. I think that, we're talking about, so last year at the World Economic Forum in Davos, there was an introduction of the fourth industrial revolution. And many countries, especially in the West, had adopted some of these things called the fourth industrial revolution. These are artificial intelligence and driverless cars and the like. And as a country, as we develop, we also cannot ignore the qualities of the fourth industrial revolution. And I think that's something that we need to consider when we're looking at growth in South Africa. Example of the fourth industrial revolution and reindustrialization of the economy is, at least now we have sustained electricity. But before we had load shedding. And how are you going to have these electrified cars if you don't even have electricity or a decent supply of electricity? And so those are the things that we need to think about when we look at South Africa in the future. The other one is, again, overhauling the economy. Does, in many, many ways, from the education side all the way to the type of economy that we want. So when we look at plans of South Africa's economy, firstly, it's the age group that plans the future of South Africa is a problem, because a lot of those who actually plan for the future will not be around in 50 years' time. So, and another thing is that because of the nature of our politics, we tend to have policies that are very short-sighted. So we suffer from short-termism. We look at plans that look at, change South Africa in the next 5 years, because politically it is sound to make plans in 5 years. But actually, plans should be for the next 30, 50 years. And are we developing, or are we looking in our policies, are we creating policies for South Africa in 50 years' time? And I don't think we are. And these are the things that we need to look at when we talk about this radical economic transformation. The other thing is that even if you look at education, so I was educated in South Africa, and then I went overseas for my postgrad degrees. And one thing that struck me is that when I got to the UK, they don't have, in my university at the London School of Economics, they don't have what we call like a BCom, BSc, BA. Especially at undergrad, they had a general degree, so you can choose 15 subjects where you do maths, science, music, history, philosophy, and that made you a far more rounded undergraduate. By the time you get to postgrad, then you specialize. And also, that feeding system feeds into the economy that they want to see in the future. So if if it is engineers that they want, or people in medicine, they tend to focus on that. Whereas I feel like in South Africa, we're still churning out people who are majoring in sociology, BA sociology, or BA philosophy. And I'm not saying that those are not desired, but the number of people that we're churning out with that qualification are not required for the country that we want. And that's why you have these unemployed youth that cannot be absorbed by the economy. We also need to dismantle monopoly structures. Again, another term that I disliked, this monopoly capital, and that's been, tallied around by some political parties. But the reality is that we have huge oligopolies in South Africa, and it makes it very difficult for smaller businesses to penetrate those markets. You see it in many industries, in the food industry, where you have Tiger Brands and Premier as the big players, and if you want to compete, it's very difficult to do so. You see it also in the property sectors, but you see it in a lot of our sectors. So it's easier to have, I think, a country that does that well is Italy, where you have many small businesses, family-run businesses versus these huge businesses that actually close competition for new entrants. We also need to change the composition, obviously, of our output. So do you know that when we had the financial crisis in 2008, 2009, South Africa was not part of the financial crisis, as in the epicenter didn't happen in South Africa. It actually started in the US and it impacted on banks in Europe and the UK. But South Africa lost 1 million jobs. No other country that wasn't in, even those countries that were involved in the financial crisis didn't lose as many jobs as South Africa did. And that's because of our linkages with a region like Europe. A third of our manufacturing products go to Europe. And I think that, again, we need to choose other markets, either do a strengthen South-South relationships, and also look at our continent, where we have over 1 billion population, growing population, which most in the main actually exports products from the US and the UK instead of exporting from South Africa. And I think that this new trade agreement that has been signed by some presidents will encourage this intra-Africa trade, which is currently 15%. Which is really, really low, and we should get it above 50%, actually. This will also benefit a lot of the South African businesses, including your sector. And I think that's something that would come out of it is infrastructure development, road infrastructure, rail infrastructure, also linking in terms of airlines, and this will benefit South Africa and the region as well. Also, another thing, lastly, is ending cadre deployment. Obviously, we know that we've had a very terrible 9 years of corruption where we saw a lot of cadres employed in specific areas within government. These cadres mainly didn't have the right experience. There was a lot of corruption. And in order to change radically the economy, I think that you need to put people who are qualified in the right positions versus those who are politically aligned. And I think that, as much as the president is very linked to the ANC, I think he's more open to that idea versus the previous president. So looking at now more sobering, why do we talk about this radical economic transformation? Why is it such a burning topic right now? And that's because we obviously have this triple challenge of unemployment, inequality, and poverty in South Africa. I'll just go through a few numbers. So 35% of Black South Africans are unemployed. Right? And if you look at the expanded definition, it's almost 71% of Black South Africans are unemployed. If you look at the wage inequality, South Africa has been considered the biggest contributor to South Africa's inequality. So this whole wage inequality, the fact that senior executives earn 10 times, sometimes 50 times more than the junior employee is a problem. You don't really see that in many countries. The richest 1% of the country's population have 42% of total wealth in South Africa. And the bottom 50% of households account for only 8% of incomes. 75% of South Africa slipped into poverty at least once between 2008 and 2015. So these are very sobering numbers, and we cannot continue like this with these statistics if we want to see growth in the country. And about 40% of South Africans lived below the lower bounds of poverty line in 2015. So the Stats SA released a document called Living Conditions last year, and in that document, it said that about 13 million South Africans live on less than 450 rands a month. So that's why you have a lot of dependency on social grants. So, I think this is, the Gini coefficient is very well known, that South Africa has one of the highest, if not the highest, inequality gap in the world. The average, which is the dark blue line in the middle, that is the average of 101 countries, and look where South Africa is. And if you look at the share of the income of the bottom 40%, it hasn't really changed. And the numbers only go up to 2015 only because their living conditions data, this is the latest data, they do this every 3 or 4 years. And STSSA, so it does these, it conducts this research, I think every 4 years. And so if you look, even since 2006, not much has changed in terms of what has happened to the bottom 40% of the South African economy, at least the very poor. But if you look at also poverty, if you segregate it in gender, 2 racial groups, Black African and colored groups, have actually increased between 2011 and 2015 in terms of poverty. So poverty in male has increased, particularly for the Black African and for the colored population. And as you know, obviously increasing the South African total. If you look at female, you see the same trend in the same racial groups. So another thing with poverty. So this living conditions data that was released by StatsSA, I think all along many of us thought that we were doing, as a country, that we were doing well to eradicate poverty, that fewer and fewer of us are actually poor and more people are moving into the middle income groups. And I think that by and large, the ANC also made us believe that. They kept on saying, you know, we're building houses, we're electrifying South Africa, we're building hospitals and schools and stuff. Up until, you know, at that time it was Padi Lekgotla who was the, Lekgodi, who was the statistician general. And he said, actually, South Africans have become poorer in the past 5 years than in the previous 5 years. And so obviously we're not doing what we should be doing. And I blame this on, part of it is that we've never really adopted to any of the plans that we said we would that are targeted at the poor. The first one was our RDP, which was mainly about housing, but also eradicating poverty and also building houses. And then after RDP, we had GEAR, which is actually RDP plus. So instead of just correcting RDP, we just have another one called GEAR, which is in addition to RDP. Then after GEAR, we had ASGISA, which is actually like GEAR, but GEAR plus. And then after ASGISA, we had the new growth plan, or new growth path, and the same thing, we just keep on loading without actually dealing with the plans and implementing some of the plans. And then lastly, we had the NDP. So the NDP was launched at the ANC conference in 2012. And when it was launched, we thought that this is the one, you know, document that was going to take us into sustained growth. I remember going on roadshows and speaking to international clients, and everyone said, finally, South Africa is on the right path. And if you look at India and China are currently on their 13th five-year plan. So we thought this is finally it. Investors were sold, South Africans were sold. Come 2013, middle of 2013, people, you know, Labour started paging through the document, which was over 440 pages, and certain sectors started also paging through the documents and say, actually, this doesn't speak to us. Labour said, no, this is not a document that doesn't align with some of the stuff that we want. So it actually never was implemented. And if you don't implement any policies, you will never know whether it is the right policy or not. And actually, that's why part of the reason why we've never really solved some of the issues that we see today. And as we go on without solving these issues, I think we start to see public anger. And that's why we see a lot of people getting very agitated, getting very impatient. There's a lot of also strikes happening as a result of this. And I think that it's for the new administration and for somebody like a Cyril Ramaphosa who wants to turn things around, it's going to be very challenging because unlike in 1994, we had a lot of patience in 1994 and we believed in the government. But currently, we don't. We are just hurtful, we are impatient, We are actually, so even any great suggestion that he makes, we just roll our eyes and think, here's another one again. He comes with Tumamina and we're just like, yawn, we're bored, we've heard this before. And that's because it's true, we're exhausted. And unfortunately, I guess, for anyone who is doing this with right intention, will have to convince South Africans that this is the right plan and he has to implement it now, or else we just lose interest. So coming to the unemployment rate. So again, unemployment, I know this only goes up to 2008, but actually if you look at the unemployment rate, even up to 1994, hasn't really changed much. On average, from 1994 all the way to actually 2018, it's still, on average about 25%. And again, it speaks to what I said earlier, that if you don't correct the skills, education, skills, training, and ensure that you put in place policies that stimulate the economy, and the unemployment rate will not change. So if you look at, this is the latest unemployment number, so the latest figure, sorry, it's the one in red, it's 26.7%. It's still 27% if we round it off. And so this is the first quarter of this year. But, people of working age between 15 and 64 years, it's 37.7 million. So obviously 40 million people are of working age in South Africa. Of that, so it's 22.4 million are part of the labor force. Those who are employed, only 16.4. Those who are unemployed, 6 million. But then here's another one. So remember that there's 40 million people. 22 million people are labor force. 15.3 million are not economically active. And out of that, many of them actually, 2.8 million are discouraged workers. And discouraged workers are those who have stopped looking for a job. They couldn't be bothered. And 12.5 can't even find a job. And then when you look at the youth, this is just in the quarter, again, so about 3.3 million out of 10 million young people aged between 15 and 24 were not employed, educated, or in training. And if you look at from male and female between the first quarter of this year and the first quarter of last year, there's a slight decline in men, so more men got jobs, but then there's an increase in unemployment in females, so 35% versus 34.3%. But again, if the youth, so much of the youth, or a big number of the youth are unemployed, what does it say for our future? The future that I said, these are the people that we're planning for. So again, how do we expect to grow the economy when you have, 10.3 million people who are not employed, educated, or in training? So a lot of you are in, this is a road freight association, so you understand cars. How do you expect an economy to grow without an engine? And that's why I always say that South Africa's economy, it's almost like a Lamborghini or a Bugatti or one of those very expensive, beautiful cars. Actually, I don't think a Lamborghini is beautiful, but very nice aesthetically. We have the rivers and the mountains and the lovely people and the food and the animals. And the engine is one of an Uno. So you cannot accelerate as quickly as we want with a small engine. And that's how we are in terms of our employment. We're this beautiful country with great potential, but we actually cannot take off into growth because we have this, we have a big population that is unemployed, a population that, if employed, could actually speed up the engine, but we can't because we still have an Uno of an engine. So here's the thing with this low unemployment rate. Remember that we had our VAT increased by 1 percentage point in February. So for my sins, I am included in the VAT panel, and my task is to, together with a group of panel members, we're tasked to either look into, add, maybe minus, some of the products that are zero rated. So the minister has chosen a few of us to look at whether more products can be included into zero-rated products for VAT purposes, especially for the poor. And it's been an interesting exercise. So just as a, a side issue. So I think there are two products that are eaten, that are consumed by the poor, that are the poor are enjoying, and the poor, and actually the poor are benefiting from zero rating, and that's fruit and vegetables. But here's the thing with fruit and vegetables, when we looked deeper into the numbers, how many fruits do you think the poor consume? Less than 5, really. But then the wealthy eat berries and kiwis and different types of just, all different fancy fruits. So actually you guys benefit from zero rating more than the poor when you look at fruits. Fruits and vegetables. Again, vegetables, the poor consume about 5. The rich eat Brussels sprouts, broccoli, cauliflower, different types of pumpkin, different types of, if you look at tomatoes, different types of tomatoes, cherry tomatoes. So the contribution to VAT is very important for employment, because the more people are employed, the more people can contribute to taxes. And if you look at the personal and income taxes, the biggest part of revenues, and that's 37%. And then the next is obviously VAT and corporate income tax. For the longest time, we've been increasing the non-direct taxes, so those are the ones at the bottom, and increasing also personal income tax. But for the first time in many years, we increased VAT. Corporate income tax, we tend not to want to do anything, only because, and I support this because many countries are actually reducing their corporate income tax. And these are like countries such as China, the US, the UK, and we don't want to lose out on that competition, because companies don't come to South Africa because they want to see the animals and swim in our beaches and consume our lovely food. They want to come here because of ease of doing business, right? And obviously there's a captive market. But if they can't do business easily here, and if taxes are high, they'll go somewhere else. So we don't want that to happen, because we want companies to invest in South Africa, to employ South Africans, to train South Africans. And so ultimately South Africans can then come up with a skill and open their own companies. But again, if you look at personal income tax, we need to increase that in order for us to have larger, or at least tax revenues that we desperately need. So our budget, our national budget, is about 1.6 trillion rands. Most of it comes from taxes, but a lot of it comes from investors who put a lot of money in South Africa. So things like, your Transnet issues bonds, the Treasury issues bonds, so that's how we get this money. So equally, more or less equally distributed, education obviously takes a priority. But this is why we need to have more people employed, so that more people can pay towards taxes, so that we can have this budget, and also reduce the debt servicing cost, which is about 10% of our total budget. The debt servicing cost is all the money that we've borrowed from investors. So again, if you look at what's happening in terms of local investment, since 2012, the government has decided, because we've got a budget deficit, so we've got this budget deficit, and we need to shrink it. And the government in 2012 decided that, look, every year we're going to reduce the ceiling, the spending ceiling, government spending ceiling. So what does that mean? It means that there is a reining in on investments, be it infrastructure, especially something like infrastructure investments, which is large. But private investment hasn't also played its role, because the private sector for all along has been looking at the politics that has been developing and thinking, no, I'm not going to invest in South Africa. How can I invest in South Africa if I don't trust the future of South Africa? How can I employ people in South Africa if I don't trust the future of South Africa? The politics, the political uncertainty, policy uncertainty is a problem, and therefore I cannot invest. So private sector hoards, and the public sector cannot because it doesn't have the money to. Ideally, what we should be seeing is that private-public partnerships, but we don't see it because there has been this trust deficit between the public sector and the private sector. But it did pick up slightly investment in the end of 2017, and hopefully we'll start to see an increase. But here's the thing with, I guess, with Tumamena and sentiment. The sentiment doesn't feed mouths. So yes, we feel a little bit better, even though politics can be a little bit dicey currently. But it doesn't always feed us. So we need to see change. We need to see more employed people, better educated people, a political system that is encouraging in terms of encouraging us to invest in it. And I put there a bunch of trucks because, again, infrastructure means that with better infrastructure and better investment, we can see more of your products on the road. So again, going back to the Lamborghini analogy of this beautiful car with a Uno of an engine. So the South African economy since the financial crisis hasn't really recovered. But here's the sad part of it is that, you know, on average between 2010 and let's say 2018 estimates, the economy is not going to grow by over 2%. Again, it shows you that there's that radical change and economic transformation that we need. We need to involve more people in the economy in order for us to see stronger growth. If you look at, let's say, countries like Brazil or Russia during a crisis, they go far beyond negative 1.5%, let's say, what we saw in the 2008-9 crisis. These economies can go into, contract by 5-6%. But because they have structurally, better educated, better skilled people, when they pick up, the pickup is much stronger than ours. Whereas with us, we don't really pick up much. We don't grow significantly above 5%. We're struggling to grow at 3%. So again, this is why we need to have this radical economic transformation or accelerated transformation in order for us to see the sustained growth. The other thing is that I guess as companies, people always want to know, why is it important? It isn't obviously important because it is important for your businesses. One time, one of our CEOs of the big 4 banks was talking about how they're going to tap into some of the African countries and because South Africa is overbanked. And I thought to myself, geez, there's so many people who are underbanked in South Africa. You're going to go to a Malawi with a population of, let's just say, 20 million people, and then those who you're going to tap into are, let's say, 5-10 million people, whereas we've got 30 million people in South Africa who are unbanked. So again, we still have a lot of people who are either unbanked or uneducated or poor that you can actually upskill in order for you, that would benefit ultimately your businesses in the future because you have more customers. Again, if you look at investment and GDP growth, the trend is similar. So a pickup in obviously in GDP growth usually sees a pickup in investment growth. Again, we need to start seeing this economy grow so that we can start seeing a pickup in investment. Another thing is that especially in the past 3 years, business confidence has been really low. Largely because of political uncertainty, the corruption noise, the leakages with these emails, but people were just not willing to invest in SA. And this is South Africans, never mind the international investors. But we're starting to see a pickup in confidence, which will obviously increase somewhat the economy. The cheapest way of stimulating the economy is through a pickup in investment. But as I can say, that is not sustainable because you need to, once you have a pickup in sentiment, you also need to follow that up with real tangible growth. So if you look at the composition of South Africa's economy, and you look at, let's say, its emerging markets peer, or even its African peers, it's relatively well balanced. One thing I like, to talk about is, let's say, look at the electricity sector. Do you know why we have an abundance of electricity? So not only do we provide electricity for some of the African countries, but currently we have a surplus of electricity. And that's because the smelters, which used a lot of electricity, consumed a lot of electricity, have gone to Malaysia and other Asian countries. So we're losing out, we lost out in investment because these companies decided that, there's a lot of uncertainty, it's not worthwhile being in South Africa, let's go elsewhere. Last year, I was at a Sasol conference, and some of the American companies that are doing oil exploration all over the world, they wanted to invest $2 billion in the country, but they couldn't do so because of the mining charter. $2 billion could have been actually one of the biggest investments in 2017. But they can't, they went elsewhere. You have a company like Rio Tinto, which is one of the second biggest mining company, specializing in iron ore mining, and yet it doesn't do iron ore mining in South Africa yet. So it's, we need to gain this confidence, we need to bring it back, we need to grow the economy, we need to have certainty in order for us to attract this investment that we want. I think a country like South Africa should be growing through manufacturing, and the manufacturing sector is about 13%. 20 years ago, it was 20% and growing. And these sectors can, I think, expand with the expansion of an African investment. Because again, if you look at other regions, Europe is still recovering from the financial crisis. Yes, you have the US growing, but you have this potentially, big continent that we can actually tap into and we haven't taken advantage of in the past. So just this slide, do you know that in retail, I found this very fascinating, South Africans spent about 32,000 Rand per second in 2017. So every second of 2017, South Africans spent 32,000 Rand on retail. So again, and this is that population that I showed you that is working, that has an income, that can consume. Imagine if the population, the unemployment rate wasn't around 35% if you include discouraged workers. Imagine if unemployment rate was 10%. How many people would consume per second in South Africa? And what that means for business in South Africa. So again, I think that, as much as you're looking at poverty and unemployment and inequality, sometimes they're very sobering numbers that we see. We don't always like to hear about it, especially some of us who are not in the lower income groups. But actually, in order for us to have a better country and even for business people to operate efficiently in this country, you need more people to be part of or more people active in the economy. So I think this is the last slide of, I know that the lady who spoke earlier talked about strikes, but what we've also seen over the years is an increase in service delivery strikes and in just strikes in general. And this is what I said earlier about people being hurtful and people taking it to the streets. And if we do not radically transform the economy, if we don't accelerate this change, we'll start seeing these strikes right at the doorsteps of our homes and also workplaces. And I think for corporate South Africa, I think for a while we've stood against the wall and folded our arms and said, hey, let the politicians do it. But I think this is an opportunity for us to get involved in the change that we want to see. Either speak to politicians, speak to people who get involved in programs that government is putting together. I think that this government is at least willing to listen a lot more than the previous government. One example is this land issue that I just want to touch up on. and there was a land summit. And even though I think that the land issue should be outside of the ANC, because it involves a lot more players, it involves legal people, it involves insurance, it involves banks. But I think that business needs to step forward and say, this is also what's going on, this is what we want to see, and submit to, make your submissions to some of these summits, and not just, stand against the wall and fold your arms, because change will happen to you, will be forced upon you, instead of you being part of and contributing to the change that you want to see. Thank you.
Thank you very much, Tabi. It's nice to hear the Gatvol word flowing so superbly from London School of Economics special. And Gavin did explain to us, he gave us the meaning of the word yesterday, so it has come up a few times yesterday as well,
okay.
and we got a definition from one of our colleagues. Right, are there any questions? Yeah, please just address to Tabi and she'll gladly answer.
First of all, excellent presentation.
Thank you.
Just a question, I'd just like to hear your comments on the brain drain. You spoke about skills shortages in this country, but at the same thing, there's also a hang of a lot of people leaving the country, the skilled people. I'd just like to hear your comments on that.
Are we taking one? Okay. I think that more and more people are coming back to South Africa. I think that the brain drain was a huge problem for the continent actually before the financial crisis. I think the financial crisis was a game changer because suddenly countries like Australia, the UK, the US were job shedding, and many people came back to South Africa. And I actually think that looking at the quality of life and what you can do in South Africa, it's easier to be here than go elsewhere. But I do think that we need to, again, work hard at containing or retaining some of the skills that we have. I think it is a myth that a lot of, especially white people, feel like they're not a part or, they're not included in some of these discussions, that they don't feel that they're being discriminated against in terms of the EE. But if you look at going to a lot of corporate South Africa, it is still untransformed. I look at this room here, it also doesn't really reflect the demographics of the country. So I think that a lot of people have come back. I think that I think South Africa has, I guess it gives you a lot of opportunities versus other countries. It's tougher out there than it is here to look for a job. And quality of life. You can go to the UK and live in a little, skodonk of I don't know if you've used that word yesterday, but a little rackety, small apartment. Or you can come into South Africa and live in a beautiful house and do exactly the same job and similar salary, actually.
Thank you so much, Tabi. Well done.
Thank you.
Very proud moment. But a quick question. Currently, I'm seeing a vacuum when it comes to our policy making between what's happening or what South Africa is aspiring to economically and what the government puts out there. And you made a perfect example about the American investors that wanted to invest $2 billion in South Africa and they had to walk away because of the mining charter. What exactly is happening in the ivory towers? Because I feel you are much closer to the decision makers than we are here. Are they cognizant of there has to be alignment between what they are, what they foresee and where they want to take the country and the policy that they put out there? The policies ultimately will, I don't know, I could be wrong, I'm not an economist, but logic tells me policy will attract investors. So what exactly is happening in the Luthuli house?
Yeah, that's a good question, and I think I see Richard there at the back, so hopefully he'll talk about such things. But here's my issue with, I don't think policy is the problem. I think we come up with great policies. And I think that there's a big detachment between what few people within the ANC who obviously would get what we want as people either in business and in corporate South Africa. But then there are others who want to derail all of this. And I think the conflict within the ANC is a problem. So something like land, for instance, land going into the conference wasn't a policy objective of the ANC. It wasn't supposed to, I believe it wasn't even tabled in the Economic Transformation Committee. And then you get to NASRAC and it became an issue. And populism obviously started, I think, won the day because suddenly now Cyril Ramaphosa has to deal with the land issue. So I think that there is a clear detachment between what those within the ANC who would, let's say, come here and speak to you and listen to this sector or this industry and report back versus the realities within the ANC and I think the disagreements there between certain parties or the factions between certain groups within the ANC. So I think, I deal with people who look at the economy. So if I speak to Godongwana, he'd totally understand it. I think if you spoke to Cyril Ramaphosa, he'll totally agree with everything that you say, or even what the sector says and what the sector wants in future. But then to go back to the ANC at the NEC conference and say, listen, this is what we want, that's where discussions change. That's where you have people within the ANC then who drag the discussion into, I think, an area where, away from what it's supposed to be dealing with. And that's why I think that the pressure should come from civil society and business, rather than letting government determine on its own how things should happen. I think in the past we let government determine, and we were shocked. And it became shock after shock after shock and horror and revelations, and that's all we did. But we didn't actually put pressure on the government. And I think now it's time to push pressure. And also, in terms of policy, I said to the energy sector, at Sasol, all their slides were aligned to the NDP. And I said, this is the only company I know that has slides that have the NDP on it. Not even the National Treasury talks about the NDP as much as they say Sasol did. And I said, how do you do that without government is not even looking at the NDP? Why are you, planning against the NDP or looking at the NDP as your guidance? And again, I thought that this is a problem because you're planning using a plan that government doesn't even consider, or is not even considering. And I said, why don't you then engage with government closely to create a policy rather than let government create a policy for your industry which you know better than they do. So these are the things I think in terms of policy making and implementation where things go wrong. It's not always a straight line, it's not always black and white. I think there are many parties involved, people are not speaking, and I think that business is not active in terms of policy creation. Right. Thank you very much, everyone.
Thank you. That was most insightful. Here we go. Just a token of our appreciation. Thanks so much for giving up your time and coming along to us. Thanks. Well done. That's great. Thank you. That was really enlightening and very, very topical and really up to date, and really has given us a wonderful idea of what we think may be happening up there. So thank you so much for that. Thanks for your time and for obviously the preparation that went into that. Now, just quickly, once again, thanks to Sasria for sponsoring the session. Tumelo Stoffel, are you still here? Would you like to just say a quick word?
Thank you so much.
Thank you.
Good morning, ladies and gentlemen. My name is Tumelo Stoffel. Normally, people, when they hear Stoffel, the first question that I get is like, kan je Afrikaans praat? And yeah, ik kan Afrikaans praten. Ik kom van een Vrystaat af, so for me, there's not a problem. Okay, so I'm not alone. I'm with my beautiful colleagues, Ntwane, Andiswa, and Quincy. So we work for Sasria. Sasria is a state-owned company. Maybe I must put a disclaimer. We are not captured. Guys, that one I can tell you. So, and the other thing is that most of the speakers that spoke since from yesterday, they've already touched on what we do at Sasria, or what will basically trigger our claims. Low economic growth, sitting at 1.3, for us, it's a problem, because obviously what will happen is that with that kind of economic growth, you'll have like low job opportunities. So economy won't be able to produce enough jobs, so people will start striking, okay? And obviously the political outlook as well. Various speakers spoke about basically our perils. So as you can see that we provide covers for civil commotion, strikes, riots. So in most cases, your normal insurance companies will not provide cover for those. So we are only the company in South Africa that is mandated to provide that type of cover. So I saw these beautiful trucks out there, you know. So then my question, or the big question, is that are those trucks covered? And it's absolutely a pleasure for us at Sasria to be here to talk directly to clients. In most cases, we don't engage with clients. We've got about 64 insurance companies that we have signed outsource agreements with. So in most cases, what will happen is that they've got mandate to sell our products. So that's when you'll hear about Sasria. So, and our premium is very affordable. I mean, for the commercial vehicles, it's about 454 cents. It's because of timing. Timing was like saying earlier on, is on the vet panel. So, I mean, it was all along 54 rand or 454. But all of a sudden, because of the impact of VAT, we've got some cents at the end as well. So yeah, so we just want to say thank you so much for the organizers of the this conference, and obviously RFA management as well, to give us opportunity to talk to you guys. And just to give you some stats to show that Sasria is relevant, you know, that I think towards the end of last month in Moy River on the highway, it's N3, yeah, that's N3. So there were like a labor strike, truck driver strikes, you know, people were protesting. And according to media, there were 122, they spoke about 102 million damages. And I think they were saying that, ENCA was saying that there were about 27 trucks that were torched and 18 were looted. Remember, it's us that as much as we don't cover theft, but when our peril is in operation, then there will be cover. So looting will be covered in that distance, you know. So we just want to say that just make sure that you are covered when coming to those type of maybe incidences. And another thing is that our loss limit goes up to 1.5 billion. So we've got primary cover, that's 500 million. And on top of that 500 million, we've got what we call excess of loss. Excess of loss meaning that you can top up your cover by another billion on top. So that cover is available. And as much as that, we've got agreements with all these insurance companies to sell our products on behalf. It is not necessary. Whether the client says, I can't afford underlying policy premium, you know, you can always ask for the standalone Sasria cover. So the cover is available, it's affordable. So there's no excuse to say that, you know what, I can't afford the premium. So all we are saying is that we are here as a state-owned company, and we are making money. We don't do bailouts, unfortunately. So we've got a strong balance sheet. Just to give you like some stats, last year, I'm talking about the last financial year, we achieved 9.5% growth, 1.8 billion, that was our premium growth. In terms of the rent value amount, we managed to achieve over 700 million profit. We made 700 million profit. So we are profitable. We are here. So it's sad because most of the speakers, I think even the political analyst yesterday, as he was speaking about the state-owned companies, even the economic analyst, he was like saying, there's a problem when coming to state-owned companies. But we pride ourselves as ASRA to say that we're here and we're doing something right. So thank you so much. It's absolutely pleasure for us to be talking to you guys. Thank you. So if there are any questions, my job was basically to introduce my company, just to say a few words, but my colleagues, Kwenzile, Ntwane, are there to answer some questions, and obviously our marketing manager, Andiswa, is responsible to ensure that we become visible in the industry. So thank you so much, ladies and gentlemen. Thank you.
Right, well, thanks very much to Sazri and to Mr. Stoffel for that. So I've no doubt they are going to be more visible. And I think that little small clause we all saw on page 4, which mentioned Sazri, I think is now coming a lot to the fore. And certainly we don't hope that events carry on like they have been doing that. But Sazri, I think, has done well to place a footprint in here. So thanks again for that.
All right, welcome back to everybody. You are the real hardcore that has remained. A number of people has had got flights that they need to catch. A number of people has left. Just everybody that partake in the RFA truck yard test, there's a certificate, looks like this. It is at the help desk. Please, if you partook in it, please go and collect your certificate. At least it's another nice memento that you can have of this conference. Our next speaker is Professor Richard Gallant, Associated Professor in Public Law at UCT. And no doubt you're all aware of late all the shocking news that we have received and heard about corruption and poor governance in business and in government, not just the one, unfortunately. And business has been criticized ever since for chasing short-term goals and at the expense of long-term sustainability and stability, and to ensure that the equity analysts and fund managers view the shares favorably compared to all the other types of things that is happening. So Prof. Gallant will share his views on this topical issue and make it a very nice interactive session. So Richard, thank you.
Thank you very much. Thank you very much, Gerrit, for the introduction, and thank you to the Road Freight Association for inviting me here. I'm glad to be here. And I hope to try and build on the last session, which has laid the platform rather nicely, accidentally, but nonetheless nicely, for the challenge that I want to pose to you. And I do want this to be a somewhat interactive session, because I know you've been sitting down for a long time. And that you had quite a big night last night as well, I'm told. So that needs to be taken into account. The topic I was asked to address was corruption, governance, and accountability in business. I've honed in on one particular word, and that's accountability. And I put it in the context, and I want to put my remarks in the context of the political environment, because my work spans law, politics, and sustainability. And it's my interest in life is always to try and find the intersection between these areas, these disciplines of law, politics, and sustainability. And I'll touch on all of them as I go through this presentation. I want to begin with a conceptual question. And I know that I'm the one that's been hired to speak to you, but I actually want you to do a bit of work for just a couple of moments. So this question of accountability, it's one of those words that is used so often and so frequently that it almost has no meaning now. It means different things to different people in different contexts. The question is accountability to whom and to what, and when, I suppose. So I want you just to pause for one moment, just for 60 seconds, put aside your thoughts about what did or didn't happen last night, the hats you wore on Monday night, that sumptuous drive over the water on the 9th on Sunday. Put all of that aside for one moment and give some thought to the question, in terms of your sector and your business, to whom are you accountable and for what? So let's pretend we're in church and have 60 seconds of silence. Just give some thought, please, to that, and then I'm going to ask you, a couple of you, just to share your thoughts. What are you accountable for, and to whom? It's a marvelous thing, silence, isn't it? Such a rare feature in our lives. So fragrant, so delicious when we have it. Anyone like to share their thoughts? Accountable to what and to whom? Yes. Accountable to your organization, your staff, yes?
My stakeholders, the board members of the companies, yeah. For ensuring that, the workplace is the best place to be for employees and that they can maximize their productivity.
Maximize productivity. Thank you, good idea. Anyone else? Thank you very much. A couple more. Accountable to what and to whom? Madam, yes.
So I would say, and this question I've raised before myself, is that I would say I'm accountable to my inner beliefs, my moral standings, and for who I stand and what I stand for. Every person has got its own belief system. For I do not have a company that I need to, or an organization that I need to, ek moet dan aandag aan gee of aan, wat is die regte woord? To be accountable to?
Yes.
I'm only accountable to myself. So that's where it starts, is my inner belief.
Okay, thank you very much. So a very different perspective. Organizational accountability here, individual accountability there. Yes, one more.
Just on that, as a father, as a husband, as a director of a company, as depending where you stand, it's the value system that you have grown up with. I think it's got a lot to do with experience and
Okay.
being around.
Okay. So individual values within different environments. Thank you. Let's take one more and then I'll move on. It's coming. Yes. Thank
Just
you,
on top of my head, accountable to our clients from a business point of view, accountable to our clients to pay claims.
To pay claims?
Yes.
Okay. You're in insurance?
Insurance industry.
Okay.
Yes.
Okay, fine. So again, a very different one. That's a market accountability. I'm accountable to the market, specifically my clients. Okay. What's interesting is, maybe it's obviously an unreasonable selection. I only picked 3 of you. Others may have thought of this, but none of you talked about accountability to society. Accountability to society. And that's the theme of my talk, and that's what I really want us to give some thought to today and to end up with some idea. I don't have the answers. This is an extremely difficult topic. But I want to pose some questions to you and try and get you to think a bit harder, because you are an important sector in this country. You have power and privilege that comes with that place in the economy. So the question for me is, what do you do with that power and privilege? How do you see your role in the society and the economy at this particular moment in history? That's my question in coming to speak to you today. So let me just put this in the political context, because politics is my middle name. I talk about it, I write about it, I spend a lot of time thinking about it, and I spend a lot of time talking to my clients, helping them to navigate what is often a very treacherous and tricky political terrain. So we've come out of a very difficult period, have we not? And this is a moment of change and also opportunity. That's very, very clear, and I think Tabby Lioko put it very well earlier, that this is a moment of opportunity, not least because we have a government that is in listening mode, that is serious about what people say to it, and you will be taken seriously if you approach that government with the right approach and with intelligent, meaningful, tangible things to say. So it's an important opportunity time for everybody, but especially for business, and especially for organizations like you. And I think you need to think very hard about how to take full advantage of that moment of opportunity. But it's also a time of ongoing political risk and uncertainty. We are not out of the woods yet. This country has extraordinary resilience. As you may pick up from my accent, I haven't always been here. I came here 24 years ago, supposedly for 1 year, but I'm still here, waiting to see what will happen next. And I'm a proud South African. Also an Englishman, but I'm also a proud South African. And this country's resilience is something that continues to surprise me and delight me. And in the last 2 years, this country has shown extraordinary resilience in coming back from the brink of what was a very, very dangerous trajectory. But we're not out of the woods yet. We have the right leadership, I would argue, in place in government now. And that leadership is doing what it can, and it's moving pretty fast. And we can talk about that in the Q&A if you're interested to explore that, because I've been given a lot of thought to how we measure Ramaphosa's performance and on what reasonable basis we assess whether he's doing what he should be doing. But in the meantime, the political and socioeconomic environment, for the reasons that Tabilioka laid out very clearly in terms of the underlying data and the underlying trends, the political risk is very much there, is it not? And I'm not sure there's a single sector in the economy which can escape this uncertainty and risk. I'm not sure if it's possible, physically or conceptually, to cut yourself off from this reality. And certainly when I think about your sector and your industry and your businesses, I would think that they are as vulnerable as many, if not most, to these sorts of impacts. This morning I was on the phone to a client that I've been advising for 10 years, a client that is a retail client with a large number of shops in this country. I won't say who they are, it doesn't matter. What they are facing is a party who are struggling to maintain their brand. And as they struggle to maintain their brand, they are resorting to more and more violent and militant tactics. So the EFF's latest habit is to enter the shops of my client and run amok. And my client this morning was asking me to write a protocol that the general managers of those stores can use when responding to that particular problem. Not easy, very, very difficult. And the Speaker of Parliament has shown in the last few years just how difficult it is to deal with that sort of problem, even allowing for her own, with respect, incompetence. So we have to think very hard about this political risk. We can't pretend we can lock ourselves away from it. It's present, it's going to continue to be present. Even if Ramaphosa, a man, I think, of extraordinary talent and ability, even if he succeeds, this will still be there. Because the underlying causes of unemployment and inequality and anger will not evaporate overnight. They will be mitigated, they will slowly, if we succeed, be reduced, but they're not going to go away overnight. And in the environment we had of the last couple of years, it's worth mentioning, I think, in passing, and this perhaps brings me back closer to the original topic that I was set around corruption in business. It does take two to tango. And we're not talking here about cowboys, we're not talking about the Guptas, we're talking about international businesses of huge standing, worth billions of dollars. And these businesses, and this is just the sort of four big ones that were swept up through their own negligence or dishonesty in what took place in the state capture project of the last few years, all of them have suffered massive reputational hits and commercial losses, have they not? And one of them has closed. And it's a tribute to the resilience of this country and its ability to fight back against the state capture project that Bell Pottinger was brought to its knees and forced to close. And the other three are still figuring out how to restore their value system, their integrity, in the face of the hits that they took to their reputation as a result of, what was it? Was it greed? Was it stupidity? Was it turning a blind eye? Was it a lack of good governance? Was it bad management? What do you think the diagnosis of their problem was? Worth pausing about. Did someone say greed? Okay. You may be right. The point is, when the environment in the political realm becomes toxic and corrupt, it can be relatively easy to be swept up in that. And clearly, business in the future in this country is going to have to guard against that and take much greater care to prevent this sort of impact. So the big question I'm posing to you in this context, and I've touched just on one element of what we refer to as the sustainability environment. Traditionally, sustainability was seen originally just in environmental terms, and then people began to wake up to the fact that the environmental impact of unsustainable development is a cause, not an effect, and the effect are economic and social. And recently we've begun also to recognize the political. Thank you. So if we go back to that holistic understanding of sustainable development and the society we want to live in as a prosperous, stable, sustainable one, the question I put to you is, well, what sort of society do you want to do business in? And what is your responsibility for helping to get there? And again, I don't have an answer. But wherever you go when you leave this wonderful place called Arabella, perhaps spend 10 or 15 minutes on your journey home reflecting on this question. Is my accountability, my responsibility merely to my organization, merely to myself and my family, merely to my clients? Or is it something bigger? Do I have a bigger responsibility for helping to shape the society and the economy that I do business in, that I live in, that I work in, that I bring my children up in, and so on? A couple of examples of what I mean here. So on the left, wearing my University of Cambridge hat, the Sustainability Leadership Institute, we work with businesses to develop sustainability strategies. So a few years ago, we worked with, this should be, I don't know what's happened to this. It's supposed to be green. If it was dark green, you might appreciate who it is. Anyone bank with them? Okay, Ned Banker's here. Okay. So when Mike Brown took over as CEO about 6 years ago or something, he took over what was called the Green Bank. But to his great credit, he looked around at the bank and he said, actually, this Green Bank thing is bullshit. It's greenwash. We're no greener than any of our competitors. We do business exactly the same way as they do. I'm paraphrasing my understanding of it. This is not his words, by the way. Don't misquote me, or him. Otherwise, I'll be in serious trouble. He recognized that if you were to be truly green, it had to be more than just the color and the words. It had to be deep in the organization, that it involved a change of business practice and strategy. And he asked us to help work with his sustainability team to come up with that deeper, more meaningful, more profound strategy. What they did, and I'm going to scamper through this, and it's not really about where they ended up necessarily, but the thought process they went through. They sat down, guided by a very crude but very effective question, which was, do you want to be in 20 years doing business in Switzerland or in Somalia? Now, it's a crude question because I don't think necessarily we want to be in Switzerland or in Somalia, to be perfectly honest. But maybe Sweden versus Somalia, if you get my drift. the point that the question was evoking was, what sort of society do you want to live in? A stable one, a prosperous one, an equal one, or one that is conflict-ridden and dangerous and inherently unstable? That was the root of the symbolism of that question. But it got the executives at Nedbank thinking. And they came up with a very interesting answer to that question as to what was necessary if South Africa was to be that stable, prosperous, sustainable society. And they came up with 8 goals. And those 8 goals, in a sense, were their version of the National Development Plan. And the 8 goals were not just economic, they were social and environmental. And they said, we are going to commit to doing our fair share to help the country get there. And then they got an envelope out, turned it over, and with a pen on the back of that envelope, they said, well, what is the investment, the additional investment the country must make to get to those, to accomplish those 8 goals within 20 years? And the figure was X billion. And then Nedbank said, well, what's our share of the market? It's Y%. And Y% of X billion is 6 billion rand a year. That was the back of the envelope calculation. Now, put aside the detail. What was important with Nedbank was the thought process. They said, well, and the conclusion they came to was that 6 billion, that's not going to be corporate social responsibility. Obviously, it's a huge sum. It's not going to be philanthropy. It is going to be core business. We are going to stretch our business model and our business strategy to do 6 billion rand's worth of new business every year, where the lending serves one or other of those 8 social and economic and environmental goals. That was their ambition. Now, we don't have time to discuss how they're getting on with that, other than to say that it's a challenge for numerous reasons. And the bottom line of that challenge is that organizational culture will eat always strategy for lunch. So you can probably tell what I mean by that. The challenge is their organizational culture. Incentives, traditional ways of doing things, old-fashioned bankers, et cetera, et cetera. So any strategic shift, any advance in conceptual thinking has to be set against the surrounding organizational culture. Can we achieve it? What else do we need to change? Do we have the right leadership? Do we need to change our structure, our incentives, and so on and so forth? The other picture there is that that's a platinum mine. So this country is sitting on, as we all know, the biggest set of platinum group metal reserves in the world. It's a huge asset to the country, but unfortunately the commodity market is uncongenial. So it makes it very hard to get this stuff out of the ground and sell it profitably. So that's part of the challenge for that industry, amongst others. So working with them recently, and again, the name of the company doesn't matter, but working with this company recently, I had my own kind of little aha moment. Because they said to me increasingly as I talked to them, we are doing everything we can to work with the communities where we mine. We build schools. We spend vast amounts of money relocating people. We provide as many jobs as we can, given the harsh economic environment. And yet still people are not happy. Still we face protests. Still our license to operate is challenged. Still they can close us down and stop our operations overnight. And this is a company, excuse me, that clearly really gets the importance of having good relations with its communities. It gets the importance. It's devoted millions and millions of rand in human and financial resources to building stronger relationships with its communities. But the truth is, and it recognizes this, that it is constantly elastoplastering it. Because all it is doing is dealing with the symptoms and not the causes. The symptoms are poverty, economic exclusion, inequality, and a sense of injustice and anger. That for hundreds of miles around this mine, there is 73% unemployment. The only real work is to be found with the mine. And so the mine naturally is the bears the brunt of all of those people's frustrations, anger, and so on. And no amount of elastoplast is going to change that. What the economists call the structural constraints, the underlying binding structural constraints, will always bite. So what can a company like them do? What should they do? It's a very difficult question. It's an extremely difficult question. It's probably an even more difficult question than the sorts of ones that your businesses would face if you wanted also to say what more should we do and could we do to build this more stable, sustainable, prosperous country. But one of the things that kept nagging at me as I talked to them over recent weeks was they kept saying, well, actually, we're not really a mining company. We take the stuff out of the ground and it gets used to make amazing things. Every single cell phone in this room has a platinum group metal in it. If you go to hospital and get operated on, a lot of the operating equipment contains precious group metals. Catalytic converters, we know, are based on platinum. All sorts of extraordinary, miraculous almost inventions depend upon precious group metals. They are an energy company or an environmental company. They're not really a mining company. The mining is a means to an end. And they need to think about how to reshape that. The point I'm getting to, before you think I've really lost the plot, is that they are beginning to grapple with and get closer to defining their social purpose. Because their social purpose is not to take stuff out of the ground and refine it. Their social purpose is to take stuff out of the ground that can be then used to do magical things for society. The problem with that value proposition for them is that they don't know where the stuff goes. They take it out of the ground. 6 of the 10 platinum group metal companies in this country refine it. The other 4 don't. But either way, whether it's refined or unrefined, that precious metal gets put into a global commodity market over which they have virtually no control. They try and control the price by moderating supply, but they have no real control over where it goes, who gets to beneficiate it, to use the word, and who then turns it into that magical piece of equipment. So the aha moment for me was, actually what they should be doing is buying Johnson Matthey. They can afford to. They've got the cash. They should buy Johnson Matthey or some such company and then control what this precious metal is used to make. And they should say, we are only going to make things that will serve certain social, economic, environmental, and political goals. And that way, our social purpose will be definable, but also tangible, and we will have some control over it. So I noticed that your strapline is, what is it again? It's something about when we drive, the country stops, or something. Yeah, you know what it is. Which is it is punchy, even though I've forgotten it. It is a punchy strapline. It captures, to some extent, your essence. You move stuff around. You're important. But can I invite you to think a bit harder about that? What is it you're moving around? For what purpose? Who benefits? Is there some way you might do that differently? What's your equivalent to these 2 companies? What are the equivalent challenges, questions that you could pose to recalibrate what you do and why you do it that would be of greater service to society? One last thought before I end. If you're looking for a framework, because clearly one of the binding narrative elements to what I've said is the idea that you have to have some conceptual framework to pin this thinking on. Of course, there are these things now called the Sustainable Development Goals. 17 goals with 169 underlying indicators that the global community agreed on in September 2015. It's notable to me that in this country, no one really talks about them. Why is that? When I go to Kenya and Rwanda, everybody talks about the Sustainable Development Goals. They're part of, in Kenya, the biggest telecom company, Safaricom, Bob Collymore, the CEO, has appointed a SDG commissar in every business unit in his company to drive business strategy in service or one or more of these goals. In Rwanda, President Kagame has replaced his national development plan in effect with the SDGs. He said, we will serve the SDGs. We will organize our business as government in service of the SDGs. Because, as the UN Secretary General has said, these are for everybody, everywhere, now. And they cover the whole thing. They cover health, education, infrastructure, the economy, politics, rule of law. And that's what sets them apart from the Millennium Development Goals that preceded them. This really covers the whole caboodle. It touches everybody's life. And it's worth thinking about. I'm not suggesting you necessarily pick them. I'm saying this is an option, to think of the SDGs as a possible guiding framework for how you think about your social purpose and the contribution that you and your industry and your businesses make to growing a more sustainable, more stable, and more prosperous society. In conclusion, and this is not an answer, it's merely a draft. It's merely to invite you to walk away from here with some thought or some question to pose to yourself as you sit waiting for your airplane or driving through the countryside later today. Knowing your social purpose, what I increasingly realize is that there are businesses who are very clear about their social purpose and those that are very vague. What is your social purpose? Know it, honor it, act on it, be truthful to it, and then, if you do those things, accountability takes care of it. Because if your social purpose is to build the economy by getting goods around the place, and you honor that, and you do it honestly and truthfully, the accountability, your responsibility in that society takes care of itself, I would suggest. Thank you for your attention. I'm very happy to take questions if there are any.
Thank you, Richard. So let's kick off. Any questions that anybody has got here for Richard? Some thought-provoking challenges thrown at us. Are you not there to take accountability right now?
Need to digest it.
No questions? Richard, thank you very much. I really appreciate that. I loved that last slide with all the 17 elements on there, and that we as a Road Freight Association could also maybe start looking at it. We were challenged yesterday on a number of occasions that we are not necessarily doing enough, and my sense and interpretation bordered more on, I think, people asking us to be radical, and I'm not sure that that is the right direction to go at all, because we cannot start stopping the roads and block them and join us and everybody else. But we need to find a way by which we can be very much relevant, even though we are involved in every single discussion that is there, and even though we attend every single meeting that we can, and we lobby everyone. And just to remind the delegates, if you really want to see all of that, have a look at the RFA Talk, the little newsletter, and it looks like a very nice magazine. Thanks, Sharmini. And you'll see all the elements where we are actually trying to lobby and work in terms of this. But this is very nice and thought-provoking, and I really appreciate that. Just as a token of our appreciation, at least, just a nice gift for you.
Thank you very much.
Right, let's just there for this picture. Just hang on, I just want to hand out the books. Also, Richard, like all good speakers, seems to be putting it down into pen and into writing. So if you look underneath your seats, there is 2 RFA cards with the name at the back written, Richard. Anybody lucky? Those who are next to a seat that is open, you've got 2 options. let's just see if we can get the two so that Richard can hand those books over to you. Have we found them yet? I'm getting worried. Nothing yet? No. It will not be very accountable. All right, let's do something else. The first two people that can name me one of the 17 elements that was on. That's it, sir. Please come up.
That was good. Well done. Well rescued. Congratulations, sir. Well done.
Just for the photo.
Say.
Congratulations.
Thank you.
Richard, thank you very much. Appreciate it. Our next speaker is Chris Charter, National Practice Head, Competition Law at Cliff Decker Hofmeyer. Now, every time I have had an engagement with Chris, mostly in terms of consultations, it has been a very enlightening experience. He's got the ability to make sense of a lot of things that I found very difficult sometimes to understand. And that is because competition law is difficult because it's so easy to get onto the wrong side of it. Inadvertently, we are an association here, and we are competitors, and we are together. So it's very easy that one could step over that line. And we have to be careful and aware of that the whole time. And for Chris to come and join us and share some of the do and don'ts of the competition law. Thank you, Chris.
Thank you. Good afternoon, everyone. This talk follows nicely from the professor's talk because I think competition law is equally about accountability. And it's equally about assessing one's role in economic society and working out what it is that one needs to do to further that aim. Increasingly, you'll see our regulator is becoming extremely active. It has a very clear policy agenda to drive. So anybody doing business in this country, and increasingly throughout the subcontinent, will need to take into account competition laws. So if you give me 20 minutes, maybe half an hour, I'm going to do this. I'm going to have to do it quite quickly. What I'm hoping this will do, though, is just give a lot of you perhaps just some things to hold on to and some clues as to what kind of conduct these days is acceptable and not acceptable. What I usually say in longer workshops and working with people is how important it is to listen to that sort of inner voice that you have. Because a lot of this stuff is instinctual and intuitive as to when you might be crossing the line. And when I've spoken to people who have been caught out, to a man and woman, what they tend to say is, you know what, if I just slowed down for 1 second and thought about it, I should have known I shouldn't have had that discussion. Or I should have known maybe this wasn't a great idea. And it's just that human ability when you're sort of in the throes of doing business Monday to Friday, of just hitting snooze on that little alarm that goes off in the back of your head. And I think one of the best things you can do is just listen, because very often that instinct is correct, and you could have pulled yourself back from something that can have quite serious repercussions. Just very briefly, just for those who don't know the regulatory framework, South Africa has a Competition Act. It's been in force since 1999. It's a 1998 dated act. It stands very well next to sort of international best practice with regard to sort of what we would consider cutting edge competition legislation. It's modeled very closely on the EU legislation and the Canadian legislation, but also mirrors a lot of the US laws and other international best practice. It's extremely wide application. It applies to all economic activity in the country. And what it looks to do is regulate three things, basically. One is merger control. The other is restrictive practices, which is conduct on a market, and there's also a provision for exemptions in certain limited cases. I'm going to spend most of this short discussion on restrictive practices, and in particular, conduct between competitors, since that's what a lot of you are today, and I think it makes sense to perhaps focus on that. Just by way of some illustration, competitor coordination is regulated by the Competition Act. Vertical restraints, which are agreements between a customer and a supplier, also looked at closely by the competition regulator. Abusive dominant position is kind of flavor of the month at the moment. We do have an economy which is quite susceptible to abusive dominance. We've got a lot of oligopoly markets. Big firm conduct is an increasing theme all over the world. Guys like Amazon, Naspers, at least Tencent in China, Google, they're all under the cosh in various jurisdictions, and this country is no different. So our regulators are looking very closely at those who are dominant within a market. And finally, of course, mergers are regulated. These are the guys who will, in fact, tell a platinum miner whether they can, in fact, acquire a platinum marketing company. So who do you deal with? You deal with the Competition Commission first and foremost. They investigate mergers, they investigate anti-competitive conduct, and then they ultimately can bring that prosecution through to the Competition Tribunal, which really makes a decision. It's a bit like a court of law. There's 3 on the panel, and it's quite a hairy situation because unlike a judge, tribunal members can descend into the arena, as we lawyers call it, and they can actually ask questions. They can actually cross-examine witnesses. So they really are keen to get to the bottom of all the facts to work out whether, in fact, any particular conduct is anti-competitive. After the Competition Tribunal, there is the ability to appeal to the Competition Appeal Court, which is a division of the High Court, and ultimately, like most things, if it qualifies, you can go to the Constitutional Court. So, again, a very brief background. Why should you worry about competition law? Late into a 2-day conference, why should you hang about to hear about competition compliance? Well, first of all, and it depends on where you want to hang your hat, but our economy is susceptible to anti-competitive conduct. Any economy is susceptible to anti-competitive conduct, but ours in particular, our political economic history, mean that we do have market structures which don't necessarily lend themselves to competitive conduct. A lot of our industries used to be part of statutory cartels. The old grain industry, the various arrangements in place with strategic products such as fuel, cement, all of that used to be really a statutory cartel, and old habits die hard. But equally importantly, it's a focus of policymakers. Ibrahim Patel, one of our more successful cabinet ministers, really is driving the competition authorities, which fall under his jurisdiction, to drive his economic policy. Competition enforcement always grabs headlines, and it's one of those things that is always going to be mentioned in any budget speech. In fact, Patel mentioned in yesterday's budget speech for his department that he's allocating fully more than a R250 million to the Competition Commission, and an increase in their budget, and essentially so they can continue to bring prosecutions. There's also been a strategic refocus at the Commission on prohibited practices. Bear in mind that so-called manufacturing and intermediate industrial products and transport will fall within that sort of intermediary level of the economic value chain, are very much a focus area for the Commission. We now plug into global regulator networks, both abroad and within the continent. Increasingly, you'll find that regulators around Africa and into Europe and the Americas are swapping notes in terms of what is going to be the next enforcement strategy. There's one thing that I would want to point out in particular. It's the leniency policy. That is a policy that's been in place now for a few years at the Commission, and what it does is it basically facilitates whistleblowing. So, particularly amongst competitors, if anti-competitive conduct is uncovered, then there's a prospect of basically corporate leniency, which is essentially immunity from prosecution if you were the first to confess that to the Commission. And most of the cartels that have been bust in South Africa have been off the back of a leniency application. So, I would urge you all just to bear in mind that. I don't use the term lightly, but there is no honor amongst thieves. And the amount of times that we've been consulting with a firm that says, well, look, maybe, a couple of years ago we had a couple of discussions and made some arrangements and understandings that we probably shouldn't have. The lawyer says, well, you can apply for corporate leniency, and they say, yeah, but it's been 2 years and it's not the kind of thing that we want to do, and we put a stop to it. And on more than one occasion, I've been on the car on the way home from that meeting, and they've called back and said, actually, maybe we should just make that call to the Commission, make sure we're in the clear. I'll make a call to the Commission immediately afterwards. The Commission has told me, look, funny thing is, 10 minutes later, someone else called me. So you're not first at the door. So it's funny how the penny drops simultaneously. I don't know what you want to put it down to, but that sort of synchronicity where, at the same kind of time, people sort of come to the same realization. So you've got to act fast, and you've got to act when you uncover the type of conduct that I'm going to describe in a short while. Again, trying to find somebody to hang your particular hat on, whatever makes you feel accountable. Moving on from the last talk. Big fines. That's as big a risk as any. Administrative penalties can be as much as 10% of your annual turnover. So it's going to hit you hard no matter what size business you are. And the Commission is becoming increasingly aggressive about imposing big fines. There's a sense that, as cartels continue to be uncovered, that perhaps compliance isn't what it should be, and that fines are a big way to deter that. There's also the prospect of being sued. So the next wave of legal action off the back of competition infringements is civil cases to sue companies who've been found guilty or have had to admit guilt. And for them to be sued by customers, possibly suppliers, on the back of what the conduct has cost them. As I said earlier, competition enforcement grabs headlines, so there's always the reputational damage to contend with. It's a PR nightmare very often to deal with even an investigation, let alone a full-blown prosecution, and God forbid a successful one. And then finally, the big stick, possibly, is the prospect of personal criminal liability for directors and management who are involved in cartel conduct. As a director of a company, you can be disqualified. In many cases, particularly with regard to tender fraud, when you're dealing with state companies, tender bid rigging is both a competition law infringement, but also a form of common law fraud or misrepresentation. And those are all criminal sanctions can be imposed for all of those. And finally, frankly, a lot of competition infringements, particularly collusion, is really a form of corruption. And that is obviously something that the world is wrestling with, in South Africa perhaps even more so. So again, it's one of those things that doesn't do anybody any good. But ultimately, it's not just about your own exposure. Compliance obviously starts at home, but it can and reducing your risk is important. But you can also, a working knowledge of the competition law can help you to not only keep your own nose clean, but to keep competitors and suppliers and even customers in line, because it's that interrelationship between all parts of the value chain which can have competition law implications. And finally, compliance can win business. Compliance is a good thing. We're moving into a world where sort of triple bottom line reporting, sustainable business practices are all part of the narrative, and competition compliance links in with health and safety, environmental and anti-corruption best practice. If you position yourself as an ethical business, that is something that increasingly customers and investors appreciate. And lastly, if your employees know the rules of engagement, they feel more empowered to go out and do their jobs. So now you know why it seems to be important to think about these things. What then does the Competition Act look to regulate? It regulates in the first instance horizontal restrictive practices. When we talk about horizontal relationships, we're talking about any kind of interaction between two people at the same level of the value chain. In other words, competitors. The the Act also looks at restrictive vertical practices, which is relationships, conduct, agreements between parties who are above or below each other in the value chain, so between customers and suppliers. And finally, the Competition Act also is preoccupied with abuses of dominance. So this is anybody with a market share of more than 35% is on the hook for sort of special consideration, because the thinking is that although the legitimate prize for competing well and competing strongly is increased market share and thus dominance. So there's nothing wrong with being dominant in a market. It's your just rewards for competing on the merits. But there's a very real risk that once you get past a certain size, the temptation gives way to stop competing on the merits. In other words, stop offering the best service at the best possible price or the best quality, but to say, well, now that I'm big enough, I can start throwing my weight around. And I stop looking to serve consumers, and I start looking to block my competitors in ways which might be unfair because of my sheer size in the market. So those of you who are fortunate enough to have more than 35% of any market, just be aware that you're sort of under special warning to make sure that the conduct and your interaction with your suppliers and customers is not one which distorts the market. Two important things to consider when you're looking at competition law compliance is to first identify, is the conduct that you're faced with either per se prohibited or outlawed on an effects-based. So the biggest concern from a compliance point of view is that conduct which is outlawed as a matter of course. In other words, it's the conduct which is outlawed, we call it per se prohibited. Other types of conduct is not always illegal, but illegal only when having a look at the actual impact on the economy, the impact on a market, it can be shown to substantially lessen competition. And those are very important distinctions from a risk perspective. And obviously the ones you need to be most careful with are those which are per se prohibited, because there really is no defense based on the fact, well, you know, my competitor and I colluded, but really together we're only 2% of the market, so what effect could it have had? Because competitor collusion is per se prohibited, no one has to look about what it actually did on the market. You're in trouble either way. Whereas certain types of conduct agreements, you know, exclusive agreements with a supplier or with a customer, those aren't always illegal. Again, that very much depends on the effect on competition, and that's more interesting to think about, but there is a little bit of wiggle room there. So just very quickly on per se prohibitions, which is where I want to sort of spend a little bit of time here. When you engage in per se prohibited conduct, there is no defense based on an ability to justify that conduct, however well-meaning that conduct is. A per se prohibited act under the Competition Act is subject to immediate penalties and sanctions. So there's no, you know, strike 2 or strike 3 before you're out. You get fined the first time that you're found guilty of that conduct. You can't rely on what will be said as sort of business sensible reasons for engaging in conduct. As an aside, I will say, you know, just about every instance of anti-competitive behavior makes very good business sense until you're caught out. But certainly you can't rely on the need to stabilize a market. That's often what cartel members say. So this was a race to the bottom. There was blood on the floor. If we didn't do this, then we would have had market exits. That's not a justification for talking to your competitor about competitively sensitive stuff. You can't rely on ignorance of the law. You can't rely on the fact that your foot soldiers went and broke the law. Their behavior will render the company liable. There's in many cases where management said, well, we didn't sanction this, we didn't know what was going on, and yet a penalty was still paid. And as I said, you can't argue the conduct has no effect on the market. Smaller players have never been able to defend themselves by saying, well, I had no option. If I didn't talk to these guys, if I didn't become part of the club, I would have been excluded. So that gives you some sense, I hope, as to kind of what's at stake. Let's move on to the kind of practice that we need to be aware of. So when we look at restrictive horizontal practices, we're talking essentially about agreements or otherwise concerted practices between competitors. An agreement, just so you know, is already very broadly defined within the Act. So it includes an agreement as you or I would think of it, which is a contract or an understanding between two people, a meeting of the minds. It doesn't matter, though, whether it's legally enforceable. It doesn't have to be written down. It can be nothing other than a sort of understanding which is developed over time. That is enough to render that an agreement. Remember that it is the fact of the agreement between a competitor which is outlawed, not the actual implementation of that agreement. So it's not a defense to say, well, I came and we discussed prices and I kind of left the meeting, having suggested that I might be on board with this, but I had every intention of cheating. It doesn't matter because you've struck the agreement. Therein lies the prohibition. But even if what's happened between two competitors is not an agreement, the Act works to also include this rather strange concept of a concerted practice. Now, what is a concerted practice? That means cooperative or coordinated conduct between firms. And this is an important bit, which is achieved through direct or indirect contact that replaces their independent action, but just does not amount to an agreement. Some people call this kind of conscious parallelism, and it's a reality of vigilant businesses that you do keep track of your competitors, and you do have a sense of what your competitor is going to do. And you engage in legitimate market research to get some sense of where you are and where the market is moving to, and you might conduct yourself accordingly. Now, all of that is absolutely fine if you do it individually. What makes it illegal is the direct or indirect contact with the competitor. It's the fact that you've rubbed shoulders with your competitor that makes it a problem. If you've taken independent views of how you're going to behave, even if it's second guessing or anticipating what a competitor may or may not do in response, that's absolutely fine. But it's that contact, which is why it's very important at gatherings like this that you always keep in the back of your mind, sometimes in the front of your mind, that you are competitors. Because right here, there is contact between competitors. There's contact at the gala dinner. There's contact out in the golf course, and conversations happen, and one has to be very, very vigilant to make sure those conversations don't stray into that which is going to lessen competition. So what is per se prohibited in terms of conduct between competitors? So when two competitors get together, what is it that the Act says you may not do under any circumstances? First of that is price fixing. Now, it seems quite obvious, but there are various grades within that which are equally prohibited. So it's not simply about agreeing a specific price. If two egg farmers got together and said, well, we're going to sell eggs from now on at 12 Rand a dozen, that is obviously a price fix. But they could make other agreements between them which don't go to the actual price of eggs. What it's got to do with the price of eggs, some people might say. But an agreement to time the increase, even if you don't agree the actual increase, say, well, next week we're both going to increase the price of eggs. That is a price fix. Okay. Agreeing a price floor below which you won't go, even though your individual prices may differ, to say we're never going to discount more than this, to agree credit terms. All of that kind of thing is price fixing. So too is an agreement to reduce the number of eggs that are sold, because that will impact the price. So there's a lot of elements within pricing, economically speaking, which you shouldn't be discussing with your competitors because it will have an impact on price. And the case law has evolved to call this a so-called price quantity quality nexus. So really the basic tenet is that an individual company should be itself determining its own prices, and to determine its own output, and to determine its own quality of service. If it starts to discuss those with its competitors, then you are treading very close to something which may be illegal. In addition to price fixing, market division is outlawed on a per se basis. Market division refers to when you allocate customers or suppliers or territories or specific types of services amongst competitors. And that can be very tempting. A market tends to settle, and people have customers that they've had for many years. And there's some kind of a general sense that I won't pick on his customers if she doesn't pick on my customers. And that's how we go forward without too much ructions, because we don't want price wars. Now, it's very tempting in those circumstances when, after 5 years of pretty much undisturbed plying your trade, a salesman from the competitor starts sniffing about one of your customers. It's hugely tempting to call up your opposite number and say, what the hell is going on? This is my customer. I've had him for 5 years. I've had him for 20 years. Why are you sniffing about? Do you really want to start a war with me? Those kind of discussions, absolutely off limits. But again, it makes good business sense to sort of stick to your knitting. And you can make those decisions independently. As soon as you discuss it with your competitor, then you're in trouble. not just customers, not just exchanging customer lists, but also agreeing that this territory will be ours. I have myself seen a case of market division where the two competitors had a map of South Africa with a line drawn right through the middle saying, that's yours and that's mine. It was that unsophisticated. But of course, there are more sophisticated ways to divide markets. You can agree amongst a number of competitors a particular market share. That'll have the same impact as essentially allocating customers. So be careful of the temptation to divide markets with your competitors. And finally, collusive tendering is the third category of per se prohibited horizontal conduct. And collusive tendering is a specific form of both price fixing and market division, whereby a tender comes up and competitors agree amongst themselves perhaps who should win that tender. And what typically happens is things like cover pricing. So it's been decided that competitor A should win this particular tender by agreement, so the rest tender in slightly higher by agreement. Sometimes it can be completely innocent in terms of the reason for it. We've had situations, particularly in the construction industry, where people are invited to tender, they haven't got capacity, they think it's too high risk for them, and they had no intention of actually tendering. But they also know that, look, if I say no to the invitation, I'm not going to invite it back again, and therefore I better stick with the tender, but I really don't have the time or the inclination to tender, so I'll call my competitor, tell him, listen, I've been asked to tender this, but I have no interest in it. Why don't you tell me your price, and I'll make sure that I tender 15% higher. Now, it feels like there's no harm and no foul, right, because you were never going to tender anyway. Again, the difference is you can decide yourself to put in a crazy bid just to keep your hand in. But as soon as you talk to your competitor about it, it then becomes an understanding or an agreement with your competitor as to what you're going to do with that bid. Then it becomes illegal. I just want to spend a couple of minutes on industry associations specifically, because we're here under the auspices of the Road Freight Association. And I think it's important to bear in mind, as you've no doubt learned over the last 2 days, that industry associations are not per se prohibited. Most well-run industry associations are pro-competitive. They are designed to deal with issues that are relevant to the industry in a broad sense. They deal with legislation as it comes. They talk about technical issues that affect the whole market. They talk about best practices. There may be some institutional marketing involved, as long as, of course, they don't talk about individual prices of companies. And they talk about technology in general. So obviously, industry bodies are something to be encouraged. They serve a very good purpose and are generally pro-competitive. But of course, remember that horizontal misconduct includes not only agreements between competitors, but a decision by an association of firms. And that is a way very often, and certainly it's a moment, the Competition Commission's pet theory is that the root of all anti-competitive evil comes from when competitors get together. And that's why even way back in 1776, which was before the French Revolution, in the middle of the American Revolution, Adam Smith, the father of economics, many say, said, listen, people of the same trade seldom meet together, even for merriment and diversion, but the conversation ends in a conspiracy against the public or in some contrivance to raise prices. So this notion that, put competitors in a room and they're going to end up with some sort of an agreement on price is not new. It's not a fanciful theory. It's one that's been a risk, at least for 300 years. So it is something to watch out for. It's not a complete conspiracy theory. Why are industry bodies considered a risk? And I want to be clear, I'm not suggesting that one shouldn't have gatherings such as these. But there are really three reasons. One is it's a platform for collusion. As soon as you get competitors together, as Adam Smith said, there's a danger they're going to start talking about something they shouldn't talk about. And human beings are naturally gregarious creatures. We are social animals. We've taken over the world, for better or for worse, because of our ability to get together and plan together. And we just are wired that way. So put us around a water cooler, or worse, put us around a beer keg or a juice bar, and people are going to start talking about things they shouldn't do. So it's not that the industry body is facilitating or raising issues in an agenda which is about prices, but leaving everybody to talk can lead to little individual cartels breaking out. Also, industry bodies are often very compelling circumstantial evidence for the Commission, who says, this looks like a price fix, but I can't find evidence of where these guys met, but hang on, they do have industry meetings 3 times a year, and if I look at the price increases, they seem to track that. So then they can use that and say, well, listen, where did you meet? It must have been in the industry body. So it can be quite compelling circumstantial evidence. And finally, a lot of industry bodies exchange or at least gather information about the industry. And sometimes those are for very good reasons. You want to understand where the industry is heading, where demand is heading very broadly. So they gather, for instance, information on the market. And it is in sometimes, if they're not careful about how that information is then disseminated to its members, there can be very granular information exchange, which can lead to a lessening of competition. So information exchange through an industry body. If people are talking about their own volumes, etc., maybe talking about future output, as soon as that gets to a level where individual competitors are disclosing their individual strategies for output, that can lead to an anti-competitive outcome. And information exchange is currently high in the Commission's sort of theories of harm as to things they're trying to root out. So, I really hope this isn't too late, coming at the end of the weekend. But obviously, it's very important that, generally speaking, your physical meetings should be on high days and holidays. The more regularly that competitors get together, the easier it is to start forming those understandings or worse, specific agreements as to how things should take place. So you shouldn't be meeting once every 2 weeks. A big function like this is a better situation because you can keep your wits about you, and you're all still getting to know each other at these things, and it's not the sort of familiarity which breeds discussion that shouldn't happen. Obviously, best practice is be particularly mindful at social events, because that's where nobody's watching. There's no agenda governing what it is you're talking about, and it's those kind of discussions you need to watch out for. One should never discuss your own individual commercial strategy or engage on your own individual commercial issues with a competitor, whether it's at an industry meeting or watching rugby at the pub and you bump into someone who you know from the market. You need to try and be very careful to make sure that you don't start discussing your own individual commercial strategy. It's very easy from that perspective to start moving into collusion. The agendas are important. Make sure if you're going to go to a meeting where competitors can be present, whether it's a tender meeting that's arranged by a customer, or whether it's a situation like this, satisfy yourself about the agenda. Make sure you don't getting yourself into a conversation that is going to be hard to pedal backwards from. And very importantly, if the conversation strays, if someone makes an overture that you're not comfortable with, in terms of inviting you to perhaps give away a little bit more about your strategy than you would be comfortable doing, or even worse, if someone says, right guys, we've got to talk about our pricing. It's on you to conspicuously object. Leave the meeting. If it's being minuted, make sure that it's recorded, that it's witnesses say this guy left the meeting in high dudgeon, because that's the way that you defend yourself in months and years to come against that. The Commission has successfully prosecuted even passive participants in a cartel. So those who sit there and they're too shy to sort of make an issue and they sort of listen in and that kind of thing. And later on they're trying to defend themselves by saying, look, I didn't even take part of the conversation, or I was just listening with interest, but I had no intention of doing this. The tribunal has said, listen, because you're there, because you're listening, because other people are making deals and are making promises, the fact that you're even there means that they're not going to withhold their side of the bargain, no matter what your own internal view is, but what you're going to do. So it's very important to get yourself out of those situations. And maybe just by way of an example, and it's a silly example, one I made up, frankly, but just by way of an example of how you start at one end of a spectrum, and then the conversation can become a lot more risky. So imagine you're at an association meeting, and one of the things you're discussing, either formally or informally, is maybe pending legislation on tire recycling. Now, that's fine. That's part of the industry body's job. Talk about legislation. What's coming up? Is it going to work? How's it going to affect us all in a broad sense? Is there something we should be lobbying against? Is there something we should be supporting? Is there something we should be getting involved in? That's absolutely fine, provided there's no agreement on market behavior or any exchange of confidential information between the competitors. So maybe the discussion evolves towards, talking about sustainable tire management. What's best practice? Is there something you can do to make sure that your tires last longer, etc.? Again, that's for the benefit of the whole industry. Those are technical issues. Those are best practice issues. It'll make us, it'll make the whole industry more efficient. There's no problem with those kind of discussions. But maybe a natural segue from there is to say, geez, what's all this going to cost, right? What are the costs of complying with this legislation if it comes in? Start forecasting what it's going to cost the industry. Again, that's quite useful to think about in terms of being able to lobby, etc. But now you're into potentially problematic territory, right? Because now you're talking about a key competition parameter such as actual expected costs. So it's a very short hop from that discussion, which is still probably okay, to now suddenly talking about your own specific costs. And maybe now people start talking about their own strategy, how they're going to deal with it. Maybe they're talking about their own costs. Now suddenly you're giving away your own confidential, business-sensitive, competitively sensitive stuff. And now you're into very, very dangerous territory. Maybe one guy with the best will in the world says, listen, cheapest, given the effect on these costs, maybe we just need to make sure that we now have a levy on any sort of long-distance contract so that we cover the cost of what we need to put to the tire recycling companies. And suddenly he says, yeah, that's not a bad idea. Now suddenly you're actually into, quite frankly, a price-fixing cartel. And now you've crossed the line. And you can see all that can happen in 20 minutes of discussion if one is not very, very careful. Related to that is just the danger of information exchange. Now, this is probably more static, so I won't spend too much time on it. It's something for the industry body to consider if it is gathering information. But very often you will be submitting information to the industry body so they can sort of maybe produce some statistics on the market as a whole. Again, none of that is anti-competitive. In fact, it can be pro-competitive if it's designed to allow you to benchmark and make sure that you're running your outfit efficiently. But be very careful about granulated information on volumes and capacity, because that can facilitate output limitation or market division, and more particularly any information that reduces uncertainty about the competitor's future conduct on a market. Okay, because there you have now, remember, the competitor contact, the exchange of information, and what you might do is if you know in maybe a small market how your competitors are going to behave, and you remove that uncertainty, it makes it easier for you to pull your punches, and therefore sort of keep things sort of on the more or less calm in terms of competitive outcomes. And often exchanging information as to what competitors are thinking and doing will lead to that sort of equilibrium in the market, which is very good for business and for planning, but anathema to a competition authority who actually wants price wars, believe it or not. So you need to be careful about that exchange of information. Generally safe is information which is non-competitive, information which is available in the public, bearing in mind that public domain information means information readily available, not something you need to find a private investigator to snoop out. Historic information which is 6 months to a year or more old, is generally going to be a lot safer to exchange. And of course, information which is aggregated, so information which is the whole industry together to show sort of general historical movements is going to be pretty safe. But anything where you can actually discern individual market shares, individual volumes, etc., from individual competitors, in other words, disaggregated information, is going to be far more problematic. An example, a tractor association in the UK, tractors, as you can imagine, a bit like trucks. Quite a small market, relatively few major competitors, and there's a big temptation amongst us to sort of keep the market nicely in a state of some sort of equilibrium, not too many price wars. These are big, expensive things to sell, once-off sales, not a huge amount of volume, so it's very tempting to say, listen, this will be my area, this will be your area. What they did in the tractor cartel was they exchanged very disaggregated granular information about who was selling in what geographic area and to what customer segmentation. And ultimately, the European Court said, look, I can't see any reason why you would do this except to support some sort of an understanding that you would be stronger in this area. And if you exchange that information almost in real time, this was sort of almost weekly updates as to who'd sold what to whom and in what municipal area, it could only be used in order to keep people on the straight and narrow. In other words, if I know we've got sort of a gentleman's agreement that this is my kind of area and these are my kind of customers. If I know on a Tuesday that you've come into my area, I'm going to retaliate, okay? Which means you hang back, which means essentially you're dividing a market, okay? If I don't know, if I'm uncertain, then you might have come in with cheaper prices, better offers, stolen some market share before even known it, and that's how you get, at least in the Competition Commission's view, a more competitive market. But it doesn't always suit competitors, who have to move their stock. So the information exchange was calculated to allow for that competitive equilibrium, which again was good for business, bad for competition. And they were prosecuted for their information exchange. So just finally then, just to remind everybody how easy it is to cross the line, and the kind of things that have been called something else, but essentially amount to cartel conduct, so-called gentlemen's agreements, unspoken informal arrangements. Look, we just respect one another. It's pretty much understood in the industry that this is how we behave, that, this customer segment belongs to this guy and not me. It's the way we've always worked. Those kind of things are basically, alternative wording for understanding between competitors on pricing or markets. As I've said, people have said, well, yeah, I agreed, but I didn't mean it. I was going to go and cheat. He was a fool to tell me what he's going to do because I was just going to come and undercut him. And I never stuck to the agreement. The fact is, it is the fact of the agreement, the fact your competitor thinks that you've agreed a price with them is enough to make you part of a two-way street and a cartel, essentially. Remember, your mere presence at a meeting where prices are discussed or where a pricing arrangement is made is enough to prosecute you. So if the conversation turns that way, do what you've got to do. Fake a seizure, pull a hamstring, get out of there, because you do need to stop that conversation, because you'll be implicated just by listening. So too, it's never been a successful defense here or anywhere that I'm aware of where someone says, well, I changed my mind at some point and there were legitimate reasons to why I set out the market. This kind of thing was, I was anyway, going to increase my price. The fact that my competitor called me and asked and I confirmed it, why is that a cartel? It is because you've got that competitor contact. You've confirmed it with the competitor. So you must make your own decisions, but you must make your decisions in word and in deed, which means, don't share them with your competitor. And finally, be careful of information exchange and signaling. Those kind of sort of soft issues, when prosecuted, can be made to look a lot more hardcore than they're meant to be. So, err on the side of caution, I would say. Industry bodies, obviously, there's something to be careful of. I hope you've all borne that in mind. Joint ventures, I've not mentioned that specifically. Joint ventures between competitors always create some sort of risk. If you are thinking of forming a joint venture with a competitor, maybe just give it some thought, maybe take some advice as to whether it's going to be legitimate. You shouldn't form a joint venture with a competitor because it's cozy or convenient or because you'd rather do something together than compete for a contract. But joint ventures, of course, can be a very, very useful way and a very pro-competitive way to deploy products and services where the two of you separately didn't have the resources or expertise or ability to do it. You can put together a new service working together. But do be careful about joint ventures. It's increasingly a theme we're seeing with the competition authorities in terms of BEE tenders, where the law's not yet been written on this, but there's a lot of current prosecution going on for good or bad reason, or which may not survive on the merits ultimately, where, for instance, you have a company that tenders by itself, and then you've got a company that tenders with a BEE partner. And how they position those tenders as competitive tenders or not is very important. For instance, it's very tempting to tender by yourself and tender with a BEE partner and say, well, because it's BEE, I can push the price up a little bit. And essentially, that is sometimes seen as a form of price fixing between really two independent companies, the joint venture and the independent company. So do be careful how you run your tender operations if you are tendering in joint venture. You need to be sure that you're not guilty of a technical price fix, because across two different bids, you've shared information between, say, two different joint ventures. And again, I mean, do be careful of sort of innocent banter. I say that only because in a world of leniency applications, what to you was just a joke or just a high-level discussion, when someone else goes and confesses to the commission, they might remember it very differently. And of course, once you've turned state witness, as it were, your incentive is to position it in the worst possible way. Now, I'm not saying that innocent imparting information is anything but innocent. It may well be innocent, but we don't want to be as caught up in a protracted investigation, possibly a prosecution, trying to prove that, really we were just having a high-level discussion and joking around, when the other guy is telling the commission, no, I definitely got the sense that he wanted me to fix a price with him, and I'm sure we came to an understanding on that basis. Then it's a he said, she said type of court case, which is hard to prosecute, yes, but also, a pain to defend. So again, find something else to talk about. If you're good mates with a competitor, and often is the case in the industry, people move around a lot. They become good friends. They meet up regularly. There's plenty of things to talk about besides your own pricing to customers. Just in closing then, I'm going to remind you that for those of you who are in charge, for those of you who are managers or directors of a company, if you are involved or if you know about a price-fixing arrangement and did nothing to stop it, under the Act now since 2016, you can in fact be found guilty of a criminal conduct. We haven't yet had that case yet, but the Commission is very reluctant to let go of that right. So, if the prospect of 10 years in a South African jail is enough to make you think twice, then cling to that. And ultimately, and this is really where we end up, prevention is always going to be better than cure. It's notoriously difficult to reach any kind of settlement with the Commission. The Commission talks settlement. For them, it's really pay now rather than after a protracted case in front of the tribunal. A compliance program is really something one should think about. The decision makers, those who come into contact with competitors or customers, so your frontline guys, your sales force, your procurement guys, these are the guys who should have a perfunctory knowledge of competition law. It's just good compliance practice. But equally importantly, amongst the foot soldiers, to make sure that the message from the top is absolutely clear. So have clear lines of accountability. So many cartels have started because people were doing things and people were turning a blind eye. There was a lot of nudge, nudge, wink, wink. There was a lot of, we shouldn't really be taught to competitors, but go out and do what you got to do. And those old habits are absolutely toxic. So you really need buy-in from the top management, from the top down, to say this is a zero tolerance culture. We happily say that with regard to corruption, sexual harassment, environmental best practice, and we really should be saying it with regard to competition compliance as well. Generally speaking, be careful about your external correspondence signifying prices. Make sure that when you're thinking prices, when you're thinking price increases, when you're thinking about your strategic moves, that you'll be able to show that these were decided upon by yourself. Your company chose what to do, that there's no evidence of any discussions with competitors about what makes sense and what impact that will have on the market, and we should do it this way or the other way. Really, competition compliance is about ongoing vigilance. You should treat it as part of your corporate governance strategy. It's not something that you can sort of hear a talk on or attend a workshop and then put back in the top shelf. This is something that people have got to make part of their thinking when they're out in the field competing. And I think that's probably a good note to end off on. It's not the Wild West anymore, and compliance is increasingly very important. Thank you.
All right, ladies and gentlemen, we've got a minute or so. Any questions for Chris? There, we've got a question.
I just, on the people leaving an organization, joining another company, obviously they sit with information, dealing with information, they can share it. How does that fit into this?
Yeah, I think that's a good question. There are two scenarios where that would be a concern. The first scenario is they might have information which they could use against you. In other words, they could undercut you, they could go after your customers, for instance. Industrial espionage is something that happens quite often. And that is from a competition law point of view, the competition law hasn't got a problem with that. That's what we would call, in legal terms, unfair competition, but not anti-competitive conduct. And those kind of things are regulated usually with restraints, NDAs. If you're talking, to a potential merger, you'll exchange commercially sensitive information. Usually people say, well, I don't want this to go to my competitor because I'm scared he's going to actually, undercut me in the market. From a competition law point of view, from a regulatory enforcement point of view, undercutting in the market is not a bad thing. So it's really, it's the purpose with which that person uses the information. Far better for you to be suspicious of him or her, to say, I don't want you to be using this against me. Maybe you've got a restraint in place you want to enforce. That's absolutely fine. If, however, you say, well, this is a great opportunity for me to have a man or a woman on the inside, now someone I can talk to, I can, if that is your outlook on that, if you think it's an opportunity to lessen competition, you should be a lot more concerned. So it again depends on the context of that. But really, it's that person should be, assuming that they are not in breach of any restraint, what they go and do on that side should be their own business. Don't give them the temptation of saying, well, call so-and-so, she used to be a good friend of ours. Now we can work out what she's doing. That's obviously that's something that will be dangerous.
Any other questions? Chris, thank you very much. Really appreciated that. And again, you made something work. Thank you. Also the photo there. Great. Thank you very much, sir. But ladies and gentlemen, unfortunately, Chris Parker has developed a crisis during the course of the morning, and he is unfortunately not going to be able to present to us today. He has contacted it, he has profusely apologized for that, but it's unfortunately circumstances that is outside of his control. So on that note, being that there's no further speakers that will be attending, just a reminder that the truck yard test certificates are available at the help center for you to pick up. And then again, this function and this convention is not possible without our sponsors. So just again, a special word of thanks to the following sponsors: Mercedes-Benz Trucks, Truck Store, Engine, Man Truck and Bus, C-Track, 5DT, DAF, Hino, South Africa, Imperial Logistics, Inware Risk Services, One Logics United Bulk, Sastria, Seven Oaks, Scania, Smart Lock, and Sunrise Express. So let's just give them a hand for appreciation. Then, ladies and gentlemen, I just also need to thank the staff of the Road Freight Association under the leadership of Shamini, but I would like to mention two people specifically. Chantel is on maternity leave, so as a result of being one person short, Charlene stepped up and took that over, even though it's not really her portfolio. And then Johan for all his immense amount of work making sure and running around. I really just want to thank them and say to you, well done, well coordinated, well arranged, and let's give them also a hand of applause. Ladies and gentlemen, if we then just try and conclude this convention in terms of moments of truth. And we started off with a debate about that size really do matter. And the moment of truth is going to come on the 1st of January 2019. When we need to see how and what we are going to do about that. But that was not the only moment of truth. We then listened to Arthur and your constitutional rights and the impact it could have. We had a look at what the economy is holding, and I'm still looking for that positive element to take out of that mass number of data we got there. And I think if I'm going to sit down now on the plane and think about it, I'm sure somewhere I'm going to find that, because we cannot just lie down. We need to keep going, and this industry is known for its resilience. We then had an outlook on the politics, and I think that is even more confusing what the economy is, but good luck for the guys that wants to be future politicians. I think you need to be a special breed of people to be able to succeed in there. But it impacts upon us. And the highlight or the most concerning point for me during the first day was a debate that ended with how should we be involved. And it was nicely touched upon by Professor Gallant in saying, how do we take accountability? Now, I think it's again important that we stress that the Road Freight Association and through its board and through its associates and through its consultants that it employs is engaged with the department on a constant basis. There's not a meeting that takes place where we are not trying to be there, where we are not trying to influence that. But we are doing it on a manner that is based upon proper research, information, logical arguments. And that is how we change and take accountability to say that we will serve. During the Easter weekend and the following weekend's trouble on the N3, we've had a number of meetings with members in Johannesburg and in Durban, asking the senior people in those companies saying, what can we do to deal with this situation, this new threat that is coming out of it? And 5 points of action were agreed upon. 4 of them has already been implemented and is running. A 5th one was mentioned that we need to get involved in the narrative of what is happening in terms of the country. Now, it's a far more difficult question to answer, and that debate will need to be taken forward. But again, it is on how we do that and how we engage. And I can give you the undertaking that the Road Freight Association will not stop to engage. We will not stop to try and influence, and we will not stop to try and do the best that we can in a legal, responsible manner to ensure that we benefit the industry and all the stakeholders in terms of that industry. But mostly, we are a free, or a, what's the right, vrijwillig? A voluntary, there, my English left me as usual. A voluntary association. And we serve our members, which is critical. And that is the persons that we need to take accountability to and who we need to respond back to. So if there's any suggestions, please bring that forward to us so that we can engage, that we can discuss about that, so that we can see how we can take it forward. We are more than willing to serve, and we are more than willing to take that matter up, or whatever that topic is, on behalf of the industry. Then just a DVD of the conference will be posted out to everybody that has attended. And then there is a questionnaire that has been handed out. It looks like this. We ask you to please complete that and hand it in at the help desk. Of course, there is reward for that risk of filling in. So you will have a bottle of wine that is sponsored by Seven Oaks. But please fill that in. It helps us in the preparation and planning for next year. And then thank you very much for your attendance. Thank you for the spirit and the participation. And if you drive home, drive safely. And when you fly home and you get there, please drive safely. And remember that without trucks, South Africa stop. Thank you very much.